we will go right into our first session on insurance class action trends. And it is my pleasure to introduce Sandy Hauser and Mike Duvall. Sandy is the head of our litigation practice at Dentons. She also serves on the firm's global litigation and dispute resolution leadership team. Sandy's clients include major global financial institutions and insurance companies, consumer products and service companies, and healthcare companies, and her practice spans numerous substantive areas, including securities, consumer fraud, deceptive trade practices, privacy, antitrust, financial markets, healthcare, and major insurance disputes involving life, health, annuities, professional liability, workers' comp, property, commercial general liability, self-insured trusts, and most recently, I'm almost out of breath, disputes related to COVID-19. Mike, there's a lot more, but I do not want to cut into important CLE time. Mike Duvall defends companies in consumer class actions, complex litigation, and related regulatory actions. Michael has defended more than 100 class actions at all levels. Wow. And for much of his career, Michael has defended insurance companies in consumer fraud and financial class actions. So without much further ado, I pass the mic on.
Thank you so much, Erica. Apologies for my lengthy bio there. I could have shortened that for you and for all of you. Really, really great to see all of you here today in person and on the web. Mike and I are going to talk about insurance class actions. And you have the materials, or you should have the materials. That is us. So here's what we're going to talk about today. Primarily, long-term care insurance class actions. That's going to be Michael, who I'm giving the mic to in just a moment. Life insurance class actions, and then a few updates from the P&C class action world. And then we are happy to take your comments and questions, as many of you in our audience are living this day to day. So Michael, I pass it to you.
Thank you, Sandy. Okay, how about now? Good? Okay, good. Okay, hello again. As Sandy mentioned, I'm going to spend the first part of our presentation discussing recent developments in long-term care insurance class actions. Our mini roadmap. First, I want to talk about sort of big picture drivers of this litigation, and then segue into the evolution that we've seen in the theories brought by plaintiffs, class action lawyers. I captioned it in the slide, latest, greatest, and worst. Those are not necessarily mutually exclusive. That's okay. And then finally wrap up under the heading of continued challenges and innovative solutions, and particularly discussing some settlements in these cases, some of which have not worked out so well, and some of which have. Big picture. I know a number of clients, both in the room and in the audience on WebEx, hello, by the way, are in this industry and understand the pricing challenges over the last several decades. But for those of you who don't, in short, as this slide sums up, this actually says in recent years, certain factors around the initial pricing of long-term care insurance policies, which for the most part were sold in the 1990s, early 2000s. These factors resulted in experience on these policy blocks that were not necessarily aligned to initial expectations. I will note that this study says in recent years, particularly around factors such as low interest rates, on the back end, low lapse rates as compared to other types of policies like life insurance. That's actually been the case pretty much the whole time. But in any event, the salient takeaway is that the long-term care insurance industry, as a result of these factors over really 15 or 20 years, has raise premiums and has continued to have to raise premium rates. Well, you can imagine how policyholders, particularly holders of long-term care insurance policies, have felt about getting rate increases 20%, 40%, 60%, et cetera. It of course, bred a lot of consumer class actions. Now, these are not recent cases that I'm showing up on the screen and on the slides, but they're context for what we're seeing really today. We had this early wave of litigation in the late 2000s, basically after rates started increasing across the industry. And there were challenges essentially to the effect of you can't raise these rates, and if you can raise these rates, what you're doing is unreasonable. And sort of the first batch of cases, courts pretty consistently held, well, the insurers can raise rates. Right there in the policy, it says the rates are not guaranteed to be stable or level, but rather they can increase. The end, 4 corners of the policy. Okay? As for the arguments by plaintiffs' lawyers that the rate increases were unreasonable, they were too high, they weren't supported, et cetera, filed rate doctrine. Okay? This is obviously like any other insurance regulated line. Policies, rate increases have to be run through every state department of insurance. That's quintessential filed rate doctrine stuff. So there's a line of cases saying it's filed rate doctrine, you can't have a civil class action that challenges these types of cases. And that includes, by the way, I bolded this case, again, not a recent case, but we'll come back to this, a case that even held that the filed rate doctrine barred claims that the actuarial science underlying initial pricing or rate increases or both could not be attacked in a civil class action. This is filed rate doctrine stuff. This is what insurance companies, actuaries do when they go to a state and request a rate increase, and the state's actuaries review that work and ultimately approve the rate increase in whole or part. So filed rate doctrine, not the stuff of civil lawsuits. So that case I cited there is 2012. Was that the end of these class actions about rate increases? No. As in pretty much any industry, any type of line of cases, the plaintiff's lawyers are very, very adaptable, right? And when we think that we've sort of put a certain type of case behind us, they come up with creative new theories. So I'm not sure who this quote is properly attributed to, but you get the point. So what have we seen now more recently? What are the trends around class action litigation concerning rate increases of long-term care insurance policies? Well, one approach, and in this case here, it's called the Scotian case. It didn't focus on whether long-term care insurers could raise rates. It didn't focus on the reasonableness of those rate increases, but it focused on the communication that went out to policyholders about the rate increases. When a rate increase is approved by a state, policyholder gets a letter ahead of their annual bill. Dear policyholder, your state has approved a rate increase in this amount and will take effect on this date. Well, in this case, the plaintiffs challenged those rate increase letters essentially with the theory that, well, it's nice that you told the policyholders what the approved rate increase is, what it's going to be, how much it's going to affect their policy, but you could have told them more information. You could have told them, for example, if the state didn't approve your rate increase in full. You asked for 40%, you only got a 20% rate increase. You could have put that in the letter. You could have put in the letter, hey, policyholder, we actually anticipate asking for another 20% rate increase, either because the full rate increase was not approved or because it's just in our plans in the next several years to request another rate increase. You could have told the policyholder that. It's a fraud by omission type of theory. The Eastern District of Virginia, in this case, held that the filed rate doctrine does not bar that type of claim, that that's essentially your garden variety fraud by omission or concealment type of case. Even though it's about the rate increases that were reviewed and approved by the regulator, even though the communications that go out to policyholders are governed by that state regulatory scheme. Court said, this is basically garden variety civil fraud. I'm going to let the case proceed to the discovery stage. We'll come back to this case in a little bit. Another adaptation of the plaintiff's lawyers has been to challenge the procurement or the process, or essentially what is encompassed in a rate increase. And this is a case that's really gotten everybody in this particular industry's attention lately is the gun case, G-U-N-N. Guns actually, several class actions have been consolidated, but the main one is gun. It's pending in the Northern District of Illinois. The theory basically is that the policy provision that states that the premium rates may be increased on a class basis means that the class includes all policyholders nationwide, such that when one state approves a rate increase, if the insurer charges that increased rate for that one state, it is violating that policy provision because other states haven't also approved that rate increase. That's basically the theory. It's kind of a lowest common denominator approach to getting rate increases. The initial citing in this gun case, both in the district court and the Seventh Circuit, concerned choice of law issues. It's a nationwide class. The Seventh Circuit remanded to the district court and basically said figure out the choice of law issues and then get to the guts of it. And as for the guts of it, the Northern District of Illinois, very recently in August of this year, held that the filed rate doctrine does not bar these claims, that these claims are not challenging the reasonableness of the rates. They're actually sort of like that Scotian case, allegedly challenging the statements made to policyholders, albeit right there in the four corners of the policy. So maybe so much for the filed rate doctrine, right? The gun case, the most recent gun opinion in the Northern District of Illinois also went on to reject plain language, four corners types of arguments. Said, well, we hear you that that the policy says what it says about rate increases, but boy, this interpretation offered by the plaintiffs about what a class means, we can look to extrinsic evidence, and that's going to get this case beyond the motion to dismiss. You can look at marketing materials. You can look at these marketing materials around riders associated with the policies that gave plaintiffs and the policyholders the alleged impression that rates would only go up for everybody if they went up at all. It's a garden variety fraud case. So this case is going to proceed past the pleading stage. Plain language of the contracts do not control or are arguably ambiguous. So much for those defenses too, I guess. Not quite. So good news, over in the District of Massachusetts, there's a case that at least to my mind goes the other way and a more perhaps logical way. The case is called Parmenter, again, pending in the District of Massachusetts. Parmenter involved group long-term care insurance. It's distinct from individual policies. In Massachusetts, there's no regime for the review and approval of group long-term care insurance rates, at least one that's not been established by the Massachusetts Department of Insurance. Well, the policy language for these policies states that rate increases are subject to the approval of the insurance department. So when rate increases were set on these policies, the plaintiffs filed suit and argued, wait a minute, since there's no actual process in place, the Massachusetts Department of Insurance has yet to set up the system for group policies. Your rate increase is not subject to their approval. It hasn't happened. There's no such thing. The defendant insurer rightly argued, well, subject to is not the same thing as previously conditioned on, and under your rationale, plaintiffs will never get a rate increase. And that makes no sense. Again, these policies, keep in mind, have been sold decades ago. So in the District of Massachusetts, common sense prevailed, explicitly so. The court held that plaintiff's interpretation was essentially nonsensical. and dismiss the case. I will note that the case is now, has been appealed, and so we'll see what happens up at the circuit court level. By the way, the gun case that I mentioned earlier is just proceeding through discovery. So what other kinds of theories are we seeing, albeit in very early on in other cases? A couple of cases that they basically go together, Collins and McHugh. And for those of you in the life insurance space, and what Sandy's going to cover, it's not that McHugh, not California. It is a California McHugh, but not that McHugh. Excuse me. In this McHugh and Collins, the theory is basically this. Long-term care insurance policies, by statute or regulation or both, had to have offered to policyholders at the time of sale inflation protection riders, meaning that if you purchase this rider, benefits would grow over the life of the policy. And the language of the rider, which is also set by statute or regulation, stated that the insurer, in offering that rider, had to certify that it did not expect premium rates to increase in a way corresponding to inflation, the inflating benefits. We do not expect a corresponding increase of your premium rates in relation to the inflation benefits. Plaintiffs in this case have essentially argued, well, you actually did expect that, and your actuarial science at the beginning of pricing these policies was off, so you either got it way wrong, or the insurance department got it way wrong in approving these rates and in approving your language of these riders. And as a matter of fact, with the benefit of 20/20 hindsight, premiums have increased as a direct result of these inflation riders. These cases are very early on. They're still at the pleading stage. We'll see what the courts have to say about the filed rate doctrine in these cases, not to mention the four corners of the policy, which speaks of the expectation, not the actual benefit of 20/20 hindsight. We'll also see if that case I mentioned earlier about the tax on the actuarial process that underlay the original pricing of policies is also protected by the filed rate doctrine. A couple of interesting cases, just interesting, frankly, involve class actions against public insurance entities. One out on the coast, referred to as CalPERS case. CalPERS is basically the California State Employees Retirement Fund. This case was actually filed many years ago and asserted similar theories as the Collins and McHugh cases I just mentioned, but really basically just attacks the ability of the insurer to raise rates. I'll get back to the settlements and what happened ultimately happened in this case in a second. But the short of the initial fighting was the state entity argued sovereign immunity. Those arguments were rejected. Case went forward. And then in this Pacific Bells case, this is currently going on. If you're into ERISA or into tax, this is your case. So this involves Washington Long-Term Cares Act, which is kind of a cute moniker. Basically, this requires payments to be made into a fund for Washington state employees that goes in part to funding long-term care insurance for them. A class action was filed actually by a sort of business-side law firm on behalf of businesses and non-Washington residents, essentially arguing that's an ERISA violation. We shouldn't have to pay into this program. The the federal district court in the Western District of Washington said that this is a tax issue, goes down to state court. So again, if you're into tax, you're into ERISA, that's your case. Pacific Bells versus Isaac or Inslee. But back to CalPERS. So again, this is a case pending in California, basically challenging premium increases. The defendant, the state entity that essentially administers long-term care insurance for its state employees, agreed to a settlement. The settlement in which it would fund to the tune of $2.4 billion of a fund in which class members, policyholders of this long-term care insurance could get refunds of their premiums up to, I believe, $50,000. Okay? Motion for preliminary approval was granted by the Los Angeles Superior Court. There was an additional $282 million put into the fund for essentially other types of relief and administrative costs. And so everyone kind of thought this case would be put to bed. July of this year, this is still what the settlement website for this class action settlement says. Under Section 19.1 of the settlement agreement, the settlement has been terminated. Why? Approximately 30% of the class opted out of that settlement. So I know there's a lot of class action lawyers in here. We put these blow provisions in the settlement agreement. So this 10% of class members opt out of a settlement, then the settlement agreement can be blown up, a blow provision. This could go show hands. Have you ever had one triggered? I actually had one triggered. Never happened, right? It's never happened. You know, I think we're all aware that no matter how hard we try, and the administrators try, and the plaintiffs' lawyers try, getting class members to pay attention to a class action settlement, whether by postcard notice or email notice or whatever, it's not the easiest thing to do. So for 30% of people to not just pay attention to the dang notice, but then affirmatively opt out of the settlement is pretty extraordinary. Okay, so why did this happen? Recall that the settlement involved essentially the refund of premium up to $50,000. It was in exchange for surrendering a policy, okay? So that was the deal. If you didn't want that deal, you want to keep your policy as a CalPERS employee policyholder, and opt out of settlements. People paid attention to this. And again, 30% affirmatively opted out of the settlement. Frankly, that's, if you look at kind of big picture trends about policyholder behavior over the course of long-term care insurance policy life cycle, consider what I said earlier about the initial sort of pricing assumptions and how those haven't necessarily borne out. Policyholders tend to hang on to their policies. They lapse at a lower rate than was initially essentially anticipated, and they oftentimes keep benefits, including, for example, the inflated benefits that I referenced earlier. So sort of viewed through that wider lens, it's actually not that surprising to see that result. So in terms of this case and where it's at, it's back to the drawing board. The parties in that case have notified the judge in Los Angeles that they are trying to negotiate essentially a new settlement, see what they can come up with. So that's, in a way, the main challenge in these cases, and particularly to trying to resolve them, is that, again, policyholders of long-term care insurance have, over time, tended to really keep these policies. Well, does that mean that there's no solution? No. Unlike CalPERS, there are settlements in which the approach has not been essentially all or nothing. I mentioned that the Scotian case earlier, so I get back to it. So Scotian case, that's the one that involved essentially allegations that the rate increase letters sent to policyholders didn't have enough information. Court said that case can proceed to discovery. Well, enough information to do what? Material to what decision, okay? The decision isn't just keep my policy or lapse my policy. The decision for long-term care insurance policyholders can be, okay, I don't want to pay that increased rate. I can't afford it. I don't want to pay for it. I don't think that I quite need this large of a policy anymore, given my circumstances. So I want to adjust my benefits and thereby mitigate against these premium increases. I want to pay essentially lower premiums going forward. I want to take this information that you're giving me about the future, and I want to make some downward adjustments. Well, the Scotian settlement essentially allows that to happen. Sends out what's called a special election letter. That letter contains some of the information that the plaintiffs allege should have been in the rate increase letters, and it gives policyholders, literally, figuratively, I guess, a menu of options that says, if you want to take this information that we're now providing you as part of the settlement and make some adjustments to your policy, downward adjustments to certain benefits, if you want to stop paying premiums altogether but still keep a pool of benefits, you can do that. And there's consideration for the settlement in addition to that information, in addition to the ability to make this decision. There's also, if the policy holder so chooses certain options, cash payments involved, which are essentially designed to remedy the policyholder who says, well, gee, with that information, I would have made a decision to lower my benefits, lower my premiums sooner. Kind of puts them in that position because the information, of course, comes after the fact. The Scotian settlement, as far as class actions go, the settlement was finally approved. It's been administered. The take rate on it was quite good as far as the class action settlement goes, meaning, again, the innovation to resolving this type of case is to find that sort of middle ground that policyholders don't have to take all or nothing, to give them some actual options in the middle. As it turns out, they kind of like it. There's a couple other cases, one of which was a couple similar settlements to Scotian, one of which was granted final approval earlier this year. The other has been granted preliminary approval also earlier this year and is scheduled for final approval at the end of this year. With that, Sandy, I'll turn it over to you.
Thank you so much, Michael. Well, we are now moving into life insurance class actions. I'm going to cover a couple things today, although honestly, the world of life insurance lapse cases has been so active lately. I'm not sure we'll get much past it, but we're going to try to give you a couple updates on class actions in other areas too, as well as the P&C world, as I mentioned. So, this is time for a break to let all of you online know that you need to put in the code word insurance in order to get CLE credit. And I believe for those of you in the room, there's a spot on the form in front of you to also indicate the word insurance. You need to use that code word in order to get your CLE credit. And if you don't remember that word, then I guess you came to the wrong session today altogether. All right, I know that many in the audience and some of you in the room are very familiar with the California lapse statutes cases, and others of you have probably never heard of this before. I'm going to walk you through it pretty quickly, but I will tell you it is a classic story of regulators and legislatures taking action, and the plaintiffs bar looking for the gotcha in that to try to capture the industry through class actions. And it's also a pretty classic class certification battle and the defense, or at least that's what the insurance industry is trying to say. So long story short, back in 2012, California enacted 2 sections into its insurance code. I put the code sections on the slide. They're also copies of the statutes that are in your booklet. Basically, California said to the life insurance industry, we are requiring for all life insurance policies issued and delivered in the state of California that individual life insurance policies include a 60-day grace period for somebody to pay premium. And also, policy owners are entitled to notice at least 30 days after a premium is due and unpaid, and at least 30 days prior to that policy's lapse, in order to give somebody the opportunity to cure and prevent inadvertent lapse. There's another requirement in the statutes as well that we call the TPN requirement, which requires carriers to allow policyholders to designate an additional person to get notice of missed premiums or pending lapse, with the explanation from California that this is consumer protective, right, and intended to avoid situations of inadvertent lapse, right, where for example, somebody has life insurance and then becomes ill and maybe isn't reading their mail, there could be another person getting that notice to make sure the premium is paid and a sufficient timeline to avoid lapse. By the way, most insurance companies, particularly for products like Universal Life, were already giving a 60-day grace period, but nonetheless, here's what California did. So statutes were enacted in 2012, became effective in January 2013. The industry proceeds to change its practices going forward. Oh, sorry, one other aspect of these statutes that becomes very important to the litigation. The statutes have some interesting language in them, and you can stare at this for as long as you want with the materials in your packet. But the statutes actually say in a couple different places, no individual life insurance policy shall lapse or be terminated for non-payment unless notice has been provided according to the terms of the statute. Another part of the statute says a notice of pending lapse and termination of a life insurance policy shall not be effective absent compliance with these 30-day notice provisions in them. So what happens? The industry, clearly observing a change in the statutes, changes their life insurance contracts to have a 60-day grace period, changes notices. I mean, most companies who comply with the statutes, and most did, change their practices to comply. But the plaintiff's bar is creative, and seeing the absolute nature of how these statutes were written, says, well, wait a minute, insurance companies, you changed your policy, you changed your practices going forward. However, you've got existing life insurance contracts in California, right? And they started bringing cases where policies that were issued and delivered prior to the effective date of the statutes still had in them a 30-day contractual grace period, saying essentially the statute applies retroactively. Or alternatively saying, each year that you pay a premium on your contract, if you pay it from California, the policy renews. That's a whole side chapter. There's been a lot of litigation over this renewal doctrine, which I think a lot of people in the room know don't make sense. So what happens in this regard? Well, at the time the statutes were enacted, the industry, of course, had a lot of discussion and needed some guidance about how to implement these statutes. And so had some discussions both among the ACLI and with the California Department. California Department didn't issue any formal guidance, but couldn't have been more clear that their interpretation was that the statutes apply going forward. In fact, that's what they said to the industry informally. That's what the SURF filings required in terms of the way the obligations were described. And in market conduct examinations of some of our clients, they clearly spelled out the interpretation of these statutes as applying going forward and not retroactively. However, the plaintiff's bar disagreed, and this was really the threshold issue in the litigation. Do these statutes apply retroactively? Well, courts went kind of all over the place on this issue. Some courts said yes, some courts said no, some courts said we don't know. That case, well, the issue kind of first got teed up for the California courts in a case called McHugh. That McHugh that Michael was referencing before, McHugh versus Protective Life. It was actually an individual case that went all the way through trial. And we'll get back to that in a minute because it turns out to be quite important, but it goes all the way up to the California Supreme Court, which says the statutes apply to all policies irrespective of when they were issued and delivered, including policies issued and delivered prior to the statute's effective date. And yes, we can see in the statutes that there's no express language on retroactivity, as we all would think the law would require, but nonetheless, reasoned in their wisdom to a conclusion that the statutes essentially apply retroactively. I've given you a copy of this decision in the papers because some of you hearing this are going to be like, what? like, how did anybody get to that conclusion? Notwithstanding that the California Department itself was saying the statutes don't apply retroactively. And anyway, there's where we are. So what happens next, right? Then the next question in these litigations become, what do these statutes mean and how do you apply and interpret them, right? Clear enough what the requirements are. You need a 60-day grace period. You need 30-day notice. Is it enough to administratively have a 60-day grace period, right? Not lapse policies in less than 60 days, even if it isn't in the contract. What does it mean in a circumstance where somebody didn't get the opportunity to fill out a form designating somebody for third-party notice? Well, plaintiff's interpretation is that these statutes are basically a gotcha. They require strict compliance and they require strict liability. And for any violation of these statutes, no matter how technical, if you didn't comply, then, you know, we can go back a few slides or you can read in the statutes. It says individual life insurance policy shall not lapse or be terminated, right? Or termination is not effective. So what does that mean? We've got all these class actions and individual cases, several dozens of them. I think we're up to 40 cases or so. I'm looking at Cassie because she's tracking these daily. There are dozens and dozens of cases, right, on this point. The claims in the case, right, there's no private right of action under these California statutes. The claims are for alleged breach of contract on the theory that once these statutes were enacted, they became part of the contracts as a matter of law. And so therefore, if you violate the statutory provision, you violated the contract, or their claims under California's UCL. I don't think I need to explain to anybody in this audience what California's UCL is, but basically a consumer fraud kind of theory or unfair business practice kind of theory for alleged statutory violations. So plaintiffs are saying, absent strict compliance, there's strict liability for any violation. The statutes themselves provide a remedy. If you didn't comply with the statute, the policy stays in force. Okay, so what does that mean, right? You're in a live life insurance policy holder who has not paid premiums in, let's say, 8 years, but your policy remains in force because you didn't get the opportunity to designate your brother to get a notice, or you got a notice that was 25 days before lapse, right? So it would be pretty consequential for the industry if all these policies stay in force, okay? Then you think about that situation for policyholders who are deceased, right? Does that mean that the companies now have to pay death benefits plus interest? Maybe they collect the back premiums or maybe not, you know, I mean, you can imagine what plaintiff's theory is here because the terminations were not effective and all the policies that you thought were lapsed are actually still in force. What are the defenses? Well, the industry has been, the industry, like literally, I think every life insurance company that's done business in California pretty much has gotten hit in class actions and individual cases, or at least complaints on these cases, right? So we have pointed out in those cases, there's no private right of action under these statutes. And for a plaintiff to try to turn these statutes into a judicially created private right of action just doesn't fly. It's a claim for breach of contract. And to establish a breach of contract, you need to show the elements of a breach of contract claim or a UCL claim, which importantly include that there was a breach and that it was of consequence, right? That there was injury and causation. So for the class action lawyers in the room, you know that injury, individualized injury, and having to show on an individual basis a breach of contract, injury, and causation is or can be the core of a successful class defense. So, you know, I put some slides in here to sort of fill out what the class defense looks like, because as you would imagine in a life insurance book, kind of unlike long-term care, you know, a lot of people, and industry research shows this over and over again, purposefully terminate their life insurance contracts, right? You might have a term life insurance policy that has level term benefits for 10 years. And in year 11, your premium increases by, you know, 100%, 1,000%, 1,300% in some cases. That isn't really a lapse. That's somebody saying, this is a term insurance policy intended to last for a certain amount of time. I don't want it anymore. I don't need it anymore. I'm certainly not going to pay that super high premium. Universal life contracts or whole life contracts, right, that maybe become unaffordable or just become more expensive over time. People abandon life insurance policies for any reason or no reason at all, right? And to say that all of those contracts that are terminated, perhaps intentionally, are somehow still in force, notwithstanding that nobody paid premium on them, notwithstanding there's been no request to reinstate them, just can't be the law, right? But this is kind of the battleground in these cases. We've opposed certification of a class on these individualized issues, right? The fact that it's a breach of contract claim and you need to show individual breach and causation and injury. We've also opposed class certification on the grounds of standing, because uninjured class members shouldn't have a claim under the Spokio decision, last year's decision in a case called Transamerica versus, or TransUnion rather, versus Ramirez. Okay, we go back to McHugh. McHugh was the case before the California Supreme Court, which held that the statutes apply retroactively, or at least apply to policies that were issued before the effective date. Well, when the California Supreme Court decided the retroactivity issue in McHugh, it remanded the case to the Court of Appeals, because what had happened in McHugh was an individual case that went to trial involving an individual who, whose policy, well, brought by the beneficiary of an individual whose policy lapsed and then he deceased. The trial court had held that the statutes apply, but the case went all the way through trial and into a jury, and the jury found that, in fact, the statutes were perhaps not complied with in their full technical glory, but there was no injury and awarded no damages, and it was a verdict for the defendant. So the case went back to the California Court of Appeals. When the case initially went to the California Court of Appeals, the California Court of Appeals held that the statutes didn't apply retroactively, and threw out the case for that reason, and then that went up to the California Supreme Court and then back down. So just this week, the California Court of Appeals issued a decision in McHugh on remand. Very closely watched case, because the issue that seemed to be directly before the Court of Appeals was, is there a causation requirement? Are these strict compliance, strict liability statutes? Well, you know, should the jury have been instructed that this is basically strict liability, or should it have gone to the jury on a breach of contract instruction? Well, I also gave you a copy of this decision from the California Court of Appeals. There are some really good things in this decision, because the court was very clear in holding that the trial court didn't err in failing to provide a strict compliance, strict liability type instruction, and the case correctly went to the jury. There's also some language in the Court of Appeals decision that indicates that the court was right to give the jury the language of the statutes, including the language that says policies stay in force. And I mean, you know, we could spend an hour on this, but the long story short is that the Court of Appeals found that the jury verdict was hopelessly ambiguous because of the way they answered questions on the California verdict form. So it's a good decision with some good language. It's also unreported, and it's also right back into the mire of litigating these cases and figuring out whether these are strict construction statutes or there's a causation defense. I put some more of the evidence in the slides here, and I want to make sure I leave time for people's questions on our session. In fighting class certification, we have put together, we meaning our firm on behalf of our clients and others on behalf of other companies, have amassed expert reports and just a huge amount of evidence on the issue of life insurance policy lapse, right? Do policies lapse on occasion because people don't get notice that they missed a premium? Sure. Do policies lapse for reasons having absolutely nothing to do with notice? Yes, of course they do. So we have done things like randomly selected policyholder files, or put forth examples through expert testimony and fact testimony of instances where people, call in and say, what do I need to do to surrender my contract, right? Or how do I get out of this insurance? Or I just joined a new company and they're giving me life insurance. I don't need this policy anymore, right? Or your premiums just went sky high. I want nothing to do with you. Slam, right? All of that happens. And so putting that before the court and, sort of using the example that I gave you guys before about guaranteed level term, where you've got premiums that are guaranteed at a certain level for 10 years or 20 years or wherever it may be, and then skyrockets. And, sort of, I don't know whether you can all see the slide in this audience. This is a schedule from an actual life insurance contract, right? Where for, some number of years, the premium stays steady at $435, right? And then at some point jumps up to, what is this number, $2,330, right? And then escalating year over year. So that's kind of what the evidence looks like. And in the papers, to sort of get the judges to understand, put in some of these examples, right, of people, people's individual circumstances that spell this out, right, to try to get the courts to say, notwithstanding the language in these statutes, you can't really find, Your Honor, that a life insurance policy on which somebody hasn't paid premium, where they couldn't have been more clear that they didn't want the coverage, is actually still enforced because of operation of law. So this is our bottom line in terms of the class defense. There have been a couple of decisions that deny class certification on various different grounds. In some cases, it's been found that there's no viable theory of damage for alive policyholders whose life insurance has lapsed, in part because many of them could get a new life insurance contract or reinstate their existing one. And there's no uniform theory of damage in a rejected class on Comcast grounds. At least one court has rejected class certification on the grounds of causation and individualized issues. Other courts have certified various classes, primarily classes of lapsed deceased policyholders, as to whom there was, like, sort of carving out certain buckets, like carving out people as to whom there was evidence of affirmative desire to terminate the coverage. So the cases right now are kind of all over the place, with a bunch of cases working their way through the courts and the push and pull before different judges coming at it from different perspectives and on different sets of named plaintiffs' facts regarding the strict liability issues. But it remains a cloud over the industry, and nobody knows really what the California Department is going to say or do on this, because they've given very little guidance, like I would say no guidance, to the industry on what their position is going to be in market conduct regarding how companies, for example, are dealing with claims that they denied in the past, right? Or even claims that come in today on a policy that's showing is lapsed on the company's books, right? But as to which maybe there wasn't strict compliance. Do you have to do an examination of the circumstances of the timing of these notices and lapses and whether there was the third-party designation? Can you still properly deny when there's evidence of an affirmative termination or not? also kind of pending across the industry is the question of what to do about this. Is there a way to mitigate the exposure? Can you essentially relapse all these policies by sending notice now, saying, hey, you might not have gotten notice within 60 days or within 30 days, or, you know, parroting the language of the statutes and saying, if you want your coverage, pay all these back premiums and come back in, right? Knowing that people are not likely going to take advantage of that, knowing that, you know, the vast majority of people who no longer have their life insurance and didn't already call to complain about it or to be reinstated don't want the coverage at all. So that is basically the world of California lapse, a classic quagmire of legislative action, regulatory action or inaction, and lots of plaintiffs, class action lawyers wanting to find a gotcha. There's also some other interesting issues that are kind of percolating around out there. We have a case called Elmore. Policy was issued and delivered in the state of Illinois. Policyholder moved to California. Do the California statutes apply? Well, you can look at the language of the statutes. They say they apply to policies issued or delivered in California. Plaintiff has a theory around that too, that if you move to California, certain language in the subsections implies that the administrative practices of the company should extend to people who move to the state of California. That's now on, before the Ninth Circuit. There's also a case called Clark versus Transamerica regarding what you do with group life. Let's say you have a group life policy that was issued to a group or issued to a trust or something in, let's just pick Rhode Island because that's one of our cases. The policy was issued and delivered in Rhode Island, but individual members of the group who have certificates of insurance are in California. Do the statutes apply to all of these groups as well, even if they're not California situs groups? So there's lots and lots of issues, right? With just, I see people in the audience rolling their eyes because the exposure really could be tremendous if plaintiff's theory were to hold. So that is the world of California lapse, and we would, I don't know whether, Dan, we have questions from our web audience. Are there questions from the group here? Tomasita?
The relapse letters, which seems like a really good solution, has that question been posed to the California Insurance Department and they just haven't responded, or like, has anyone tried?
Well, okay, so the question is, has anybody asked the California Department what their view would be on a relapse strategy? And the answer is no, not to my knowledge. There's certainly been no public discussion with the California Department on whether a relapse strategy could work or not work. There are lots and lots of technical and administrative issues with it, right? Like, for example, how do you cure the fact that somebody wasn't, before the initial lapse, given the opportunity to designate a third party for notice? Right. Another question, if you initiate a relapse strategy, what do you do with all the potential deceased, right? If you're reaching out to your current alive former policy owners, giving them the opportunity to reinstate because there was a potential statutory violation, what do you do with respect to those on which you might have to pay claims, and how do you sort that, right? So there are all of these issues, and it's a challenge for any company to work their way through it because you've got all this litigation, you know, pending in the courts. And really up until this week, we thought there would be real clarity from the California courts on whether there's a causation requirement or not. You know, instead we got some good language on causation and a really weird decision throwing the case back to the trial court on the basis of a hopelessly ambiguous verdict form. So lots of questions still out there. But your question, Tomasita, is one that I think every life insurance company is asking. right? And what do you do with your group book, not knowing whether or not the statute applies? Okay, well, if there aren't any questions on that, as promised, have some notes from our partner who couldn't be here today, Mark Hanover, who, among others in our firm, is handling a bunch of class actions against the P&C industry that equally could take another hour of time, and perhaps we'll do that at our next insurance symposium. He points out a couple trends that probably most of you in this audience know about, but in the P&C world, there are groups of plaintiffs' class action lawyers that continue to weaponize companies' use of claims adjustment software of various types and across various lines of insurance. And there continue to be class actions all over the country challenging companies' methodology and vendors' methodology as either systematically producing values that are too low or because they use algorithms that are collusive or illegal in various ways. And have some interesting and creative theories of damage. If that's an issue that is affecting all of you, Erica's worked on a number of those cases. Our partner, Mark Hanover, has worked on a number of those cases. Others in the room have as well. Talk to us about that after. Mark also points out and would add to our discussion that there continue to be lots of class actions regarding ambiguity in certain terms in P&C policies, including depreciation, actual cash value in auto and homeowners cases and in other cases as well. So flurry of activity there as well that we don't have a lot of time to get into in specifics today. So with that, I think I'm going to pass it back to you, Erica.
Thank you,
everybody, for your time.
Thank you, Sandy and Mike, for that wonderful presentation. I think we have a couple of minutes before our next session. Ethics for Insurers will start promptly at 2:10. So feel free to grab a snack or a drink or a lunch if you've just joined us, and we'll come right back at 2:10. Thank you. Okay, everyone, we're going to start up again in a minute. But it's so wonderful to see everyone catching up and having fun. Our next presentation is on ethics for insurers. And I am proud to introduce our panel today. Sherry Clevens is an experienced lead trial and appellate lawyer who handles cases in state and federal courts across the country. She has several decades of experience successfully litigating matters involving allegations of breach of professional and fiduciary duties, insurance coverage and bad faith, breach of contract, business tort disputes, concealment, misrepresentation, and fraud, among many others. Alana Claire is a partner in the Dentons Law Firms Group and in the Insurance Group. Her practice focuses on insurance coverage and bad faith defense, professional liability and law firm defense, and commercial litigation. Alana is currently the co-chair of the Attorneys Liability Subcommittee of the ABA's Professional Liability Litigation Section. She's also a member of the CLE Committee for the ABA Center for Professional Responsibility, and she was named a Law 360 Rising Star for Insurance this year. Sherry and Alana have written several books and articles on the issues that they'll talk about today. We also have Scott Barabash, who's Senior Vice President at Aspen Insurance in Jersey City, New Jersey. Scott currently oversees their professional and financial liability claims teams He has more than 20 years of industry experience, including claims handling and supervising claim handlers of a variety of professional liability and financial liability claims, including lawyers, accountants, broker-dealer, management liability, D&O, A&E, real estate professionals, consultants, title agents, public entities, cyber, and other miscellaneous professionals. So let me flip it over to our wonderful panelists.
Thank you so much. Oops, can you hear me okay? Is that coming in? Okay, great. Thanks so much, Erica, and thanks to everyone for having us. We all have a lot of experience in both insurance and ethics, so hopefully we'll be able to give everyone at least something that they can take away that they haven't heard before. Sometimes it can be hard because everyone's required to take ethics credits to provide something new because everyone gets ethics every year, and we're trying to come up with some topics that hopefully are a little bit different, but that also span a broad number of topics to kind of touch something, hopefully, like I said, for everyone. Some of the things we're going to talk about today are attorney-client privilege and work product doctrine and how that plays out in the insurance industry and in the insurance space, particularly as it relates to in-house attorneys at insurance companies, and also in connection with claims handling practices. We'll talk a little bit about using and naming captive law firms, risks of unauthorized practice of law, which has become a very timely discussion of late because so many people are working from home, sometimes working on vacation or other places where they're not always admitted to practice. And that comes into play as much in the corporate space as it does in law firms, where all of us are often working remotely. And then we'll talk about use of outside counsel guidelines and panel guidelines and the ethical implications of that, and who-miss counsel issues and tripartite relationship issues as they arise in the claims handling situation. Okay, so the first thing that we'll talk about is the unique role of in-house counsel at insurers. So in-house counsel are in a unique role, whether you're working for an insurance company or you're not. You have obligations to multiple clients in some instances. Sometimes those people are your employers. You're being asked to provide sometimes a blending of both legal and business advice. And that can be a tricky situation that implicates quite a few ethical issues. It can be even more complicated in situations where you're dealing with claims management and trying to address avoidance of risk in managing claims for your employer. And so we're going to talk a little bit, as I said, about some of those issues and how they're implicated in a variety of scenarios. There are also internal compliance issues. Obviously, insurance companies are highly regulated, so that implicates some additional concerns, including, for example, ensuring that the advice that you're providing to your employer, who's also your client, complies with all of the necessary regulatory requirements. And many of you are in the situation of also supervising outside counsel. You're hiring outside counsel sometimes to provide advice to, the corporation itself. But in the claims handling space, there's often an additional layer where you're hiring outside counsel to represent a third party who is your insured. And that creates a little bit of a different situation because now the attorney that you're hiring may have multiple clients, and we'll talk about the tripartite relationship at the end of the presentation, but it creates, in some situations, a concern about a divided loyalty or a situation regarding confidences and privilege. So those are some of the reasons that working in-house at an insurance company can really implicate ethics issues that not everyone else in other corporate circumstances will see or have to deal with. It requires the in-house attorney to be really knowledgeable about both the substance of the law that they're dealing with, i.e. the insurance law, sometimes the law of the defense that they're handling, as well as claims issues and other coverage and litigation concerns. Do you want to add anything to that, Scott?
Sure. So I come at this from a claims perspective. So one of the things, there are two times or multiple times that we as claims folks hire counsel. One of them, or most of the time, I deal with third-party claims against my insureds, and I'll be hiring counsel to represent my insured. There are other times where I'll be hiring counsel just to represent us directly. And in those two relationships, it's tough to manage sometimes to know when to keep them separate and when to have communication between the two different types of firms that I'm hiring. The other thing that I guess I would talk about, I would like to point out is, you know, as Sherry was talking about, is knowing the different types of laws and substantive laws nationwide, as well as local jurisdictional laws. I think there's a couple things. For example, I think I heard some people talking earlier that they came in from New Jersey. Well, if you have a legal malpractice case in New Jersey, it's the only case in the only state in the nation, the Garden State, where you can, if you prevail as a plaintiff, you get your attorney's fees. It's a key sort of thing that makes it unique and different than any other state in the country, and it's something that you have to consider. Alternatively, you know, I'm always looking, what are the joint and several liability laws depending on the jurisdiction? So, you know, we're going to rely on that local counsel a lot, but also you kind of want to bring to the table as an in-house person some knowledge of what all these different types of laws are that you're going to be dealing with.
Yeah, that makes a lot of sense. I think next we're going to have Alana talk a little bit about the attorney-client privilege and work product doctrine.
Great, thanks, Sherry. So just to kind of set some base levels for what we're going to be talking about for the rest of this hour, we're going to talk a little bit about the attorney-client privilege and also the work product doctrine. So when we talk about the attorney-client privilege, we're talking about communications between an attorney and client made for the purpose of obtaining or providing legal advice. And that's an important distinction because it doesn't mean that every communication between a lawyer and client is privileged. And it doesn't mean that every document that passes by a lawyer's desk is also privileged. It has to be a communication made for the purpose of seeking or obtaining advice. As a matter of public policy, courts are pretty uniform in protecting and enforcing the privilege. We obviously have a public policy interest in encouraging people to consult with their counsel, and this is true in the civil context as well. There are exceptions, though, to the attorney-client privilege that come up a lot in the context of insurance claims handling or litigation. The first of this is not necessarily in commonality, but perhaps in the level of interest, is the crime fraud doctrine. This is an exception to privilege that allows disclosure of communications that are made between an attorney and client for the purpose of committing a crime or fraud. This comes up in the insurance context from time to time when there are allegations or concerns that an insured, for example, has been engaged in deceitful or fraudulent conduct in trying to obtain coverage for a claim. Another factor that weighs into the application of the crime fraud doctrine is whether the attorney was hired for the purpose of assisting with the crime and fraud. So there is a pretty high standard on the movement, the person who's seeking to disclose attorney-client privileged information. But if they are able to make a prima facie showing that there's reason to believe that there were such communications between an attorney and client, they can be disclosed. And Sherry and I have had a couple of cases even in the last few years where in representing an insurer, we have compelled communications between the insured and their lawyer on the grounds that those communications were in furtherance of a crime or fraud, typically to defraud an insurance company. And as courts become more comfortable with this aspect of the crime fraud doctrine, we think we're going to see this more and more as an exception to privilege, a waiver of privilege that leads to further productions. The more traditional exceptions to privilege include just general waiver. You know, if you send around your lawyer's in-house memo and send it to other people, you've likely waived the privilege surrounding that memo. And then another thing that comes up in the context of insurance defense is the presence of a third party. The privilege protects communications between attorney and client. If there is someone who is not the attorney or employed by the attorney and not the client in the room, there can be a waiver of privilege. However, even though waiver is an exception to privilege, there's an exception to this exception in the insurance context. Sherry and Scott previewed this a little bit, but in the tripartite relationship, or the relationship where an insurer is funding a defense or participating in a defense on behalf of an insured, it's typically recognized that privileged information can be shared in that relationship without waiving it.
I want to jump in just for 1 second and just note that on this waiver as it relates to third-party, witnesses or information provided to third parties, remember that communications in cabs and airports that can be overheard could result in a waiver of privilege. And there was an article just, I think, yesterday in the ABA Journal about a waiver of privilege that a court found when a party forwarded an otherwise attorney-client communication to hotel staff to have it printed so that they could use it in a meeting rather than using a business center to have it printed or other confidential means. So you need to be very, very careful, we all do, in terms of protecting that privileged information.
And Sherry has now accomplished the main goal of most ethics presentations, which is to scare everyone who's listening. So now everyone's sufficiently frightened. One other thing to note about the privilege is that although it protects these communications, it doesn't typically protect underlying facts. So the fact that an attorney is conveying to a client, like, these are the facts of the case that we've learned, there are arguments about whether something like that is privileged. This also is a unique situation for in-house counsel. Typically, when a lawyer is acting as in-house counsel, the client is the company. Typically, the client is not the individual executives, the claims adjusters, or other people that they may be working with. And there can be some real risk for in-house counsel because sometimes they serve both a legal function and a business function. They facilitate the giving and receiving of legal advice, but they may also be facilitating business decisions or weighing in on business decisions. So just because your in-house counsel is involved in a communication or a discussion doesn't mean it's privileged. Courts will look at the purpose of the discussion and kind of what hat the lawyer was wearing. And we put a couple of examples here on the slides. If the in-house counsel is helping review and assess potential exposure to the company and making recommendations to the company, that's likely privileged, it's likely protected. But as with some companies, if the in-house counsel is also dealing with HR issues and weighing in on hiring and firing decisions, those may not be protected by privilege unless the reason the attorney is involved is because of the potential legal exposure of the hiring or firing decision. And again, this only protects legal advice. It doesn't protect business advice. And that's something that can be helpful for in-house counsel to keep in mind. Now we're going to talk about the work product doctrine. It often goes hand in hand with the privilege, but it protects very different things and arises in different contexts. So the work product doctrine protects those documents and materials that are prepared in anticipation of litigation. And that's the key phrase, in anticipation of litigation. We're going to come back to that. In many states, it's a federal doctrine that's recognized, but many states also recognize the work product doctrine. And some of them will distinguish between ordinary work product and opinion work product. Ordinary or fact work product is typically, summaries of interviews with witnesses, the gathering of evidence, documents that describe the facts of the case and some of the work that attorneys have done. Opinion work product, which is typically subject to a higher protection standard, protects the lawyer's mental impressions of that. So advising on the course of conduct, on the likelihood of success, those sorts of things typically constitute opinion work product. And even in a crime fraud situation, like we described a little bit ago, sometimes even opinion work product will remain protected through that, given the kind of high bar that it has. It's harder to waive work product protection. You typically don't waive it in the same way that you waive privilege. Courts typically require that in order to waive work product that you give it to a litigation adversary. So sharing a work product memo with someone else in the company or even sometimes with a third party will not always result in a waiver, so it's a little different here. But adversaries who want to obtain work product information typically just have to show that it's necessary and relevant to the litigation at hand, that there's no other way that they can obtain it except through getting your work product information, and a substantial need for it. So it's still a fairly uncommon occurrence for discovery to happen this way, but that's how the work product doctrine differs from the privilege. So we're going to take a little poll of the people here in this room about where we draw these lines about anticipation of litigation. And we have a few examples here on the slide that, if the room will indulge us, we'll ask people to raise their hands.
Everyone sat up a little straighter when you
They did.
we were going to take a poll.
So we're going to give some situations in which litigation may be anticipated or not. And if you think litigation, it's reasonable to say litigation is anticipated at this stage, please raise your hand. So the first one, as soon as an insured makes a claim for coverage, no hands. When the claim is referred to a senior claims representative, also no hands. When a reservation of rights letter has been sent, a couple of hands. When the insurer first gets a letter from an insured's lawyer, more hands. When the insurer is considering a DJ action but has not filed one, more hands. These are obviously in increasing severity and perhaps closer to litigation, but there are cases on almost all of these scenarios. Typically, as soon as an insured makes a claim for coverage, it's just a claim for coverage. It's typically not viewed that that's a triggering point for the anticipation of litigation. But there has been some discussion lately about coverage issues that are becoming more uniformly acknowledged. So for example, if a business owner makes a COVID-19 property damage claim, with that, as soon as we get this letter, do we know it's going to litigation? Because all of those claims have been going to litigation lately. For the senior claims representative, typically based, I'm sure, on our shared experience, when claims are directed upwards, it's sometimes because they're more complicated or there's a special issue involved. It's not always because the parties, or excuse me, the insurer anticipates litigation. But there is a case in Georgia that found that that was the triggering point for a work product protection of information. Because once you're moving it up the chain, it's because you're worried about exposure. I don't know that we necessarily agree with that decision, that the act of referring a claim upwards internally is a signal that you anticipate litigation, but at least one court has found it. RORs obviously can vary in their severity and degree, and for some of these other claims that are a little bit, situations that are a little bit closer down the line, it'll become a very fact-heavy decision. One other factor to consider, though, is if you do anticipate litigation in a claim, it's also helpful to consider that hand in hand with issuing a litigation hold. If you're trying later to establish when the date was that the insurer began anticipating litigation, but they did not at the same time start securing their documents and asking people involved to preserve their information, it may be a harder argument to say, yeah, we anticipated litigation at that time, we just didn't do anything about it internally. So now we're going to talk more about preserving the privilege.
Yeah, and on the work product issue, it's interesting because you rarely have to make a work product decision as to whether or not you're going to claim that the work product doctrine applies until you're in litigation and you're asked to provide information and you're making a decision about the date on which you're going to say that you anticipated litigation. So Alana's very right that when you're making that determination, check your lit hold date to make sure that you're not saying that you anticipated litigation at a point that was well before anyone within the company was acting as though litigation was coming. So the next topic is about preserving the privilege. So I already gave a couple of examples of situations where there could be a waiver, but more commonly where we see issues regarding preserving of privilege, it relates to the kind of advice that's being offered and whether or not the privilege actually even attaches in the first instance. And one of the things that courts will often look at after the fact is basically what was the role of the person who was providing the advice? Is the advice really truly legal advice, or is it a blended legal and business decision? And it's frankly the more likely, where it's more often a business advice or blended advice, there's also a potential risk that the attorney in that scenario can become a witness because they're actually moving into a decision maker role rather than staying in the role of counsel. And courts look at that very carefully in terms of what is the role of the lawyer? Is the lawyer acting as essentially a witness who has key facts or merely providing advice that should be subject to protection? And one of the factors that we often look at is whether or not the lawyer was, for example, engaging in communications with the opposing party in a deal, or whether they were behind the scenes providing advice to the deal, you know, representatives who were then communicating directly. So those are some of the things that courts will look at to try to determine whether the privilege attaches or it does not. Scott, maybe you could talk a little bit in your in-house role, what kinds of situations you've seen.
Yes, so we're hiring outside counsel, and there's a couple things, I guess, that I would discuss. So first, I would think about when we're hiring counsel, obviously there's a reason for it. But the first question that comes to mind is, do I want to let everybody know that I've hired outside counsel? And sometimes I might want to keep them under the scenes and under the radar and communicate directly from me. And so I'm making the decisions, but I'm also consulting somebody to make sure that we are properly investigating whatever it is. A lot of times I'm dealing with it, it's probably because there's a coverage issue that might be there. However, it might be something just because I want somebody who's a second set of eyes to look at the complex type of case that I have. So in those situations, in both of those situations, I might not want somebody to come out of the shadows and communicate directly with an insured or defense counsel. Because once you have a third-party counsel or an outside counsel, you know, working on the case, then all of a sudden everybody gets their backup. And I think that at that point, the way the posture of the case just changes, and then all of a sudden the insured is going to get on the defensive. But at the same time, I might not be looking to do something that relates to something that was privileged or anticipation of litigation. I might just be looking at like, hey, you know what, this is a complex case, high exposure. I want somebody to just, you know, to make sure I dot my I's and cross my T's. But then if I end up, you know, then it could but then it could also take the next step where, okay, all of a sudden I'm like, okay, wait, there's something that went on here that was not right. And so I want to have my counsel communicating with the insured, making sure that they're aware of their rights and that we're protecting the file and making sure that there is that separation and that the communications are privileged and that there is no waiver of that, or that they, you know, just to make sure the file is in good shape for if we do have to take it to the next step and maybe litigate with an insured or maybe even a third party. There could be situations where you have that. Or if you have, we'll talk more about independent counsel. That could be another situation where we deal with, you know, almost an adversarial situation sometimes, but you're, you know, so you want to have counsel on it to represent the carrier.
Now, there may be situations where there's been an accidental waiver of information. There are also some circumstances where you actually want to waive intentionally. You, for example, want to take the position that you acted a certain way and that action was justified because you relied on a lawyer in making the determination. I would say we should all be really careful about using the advice of counsel defense because a lot of courts find that when you waive the privilege in connection with advice of counsel, it results in a subject matter waiver of all information related to that advice. And so it can be a very, very broad waiver, and it can result in some instances I've seen it result in almost a complete opening of the books of the lawyer as outside counsel with respect to the subject that exists in the legal opinion. So it's really important to be careful of it. There are times where it's appropriate to use it. And I don't know, Scott, if you've had much experience with it, if you want to add anything on that.
Well, yeah, I've had experience. And, you know, one of the things as an in-house person, I've been deposed, and there was an instance where a long, long time ago, somebody asked me a question, and my initial instinct was, well, I asked my attorney. But then immediately I caught myself, and it was, you know, one of the things that you have to make sure is that you don't say that it was your attorney who gave you the advice, because now all of a sudden you've destroyed that attorney-client privilege, and everything that you've talked about could be subject to disclosure in that litigation. And so that was one experience that kind of always stuck with me, that I kind of caught myself, but I could see easily, and as an in-house person, not being cognizant of that and just, you know, off the cuff, because you did consult your attorney, but ultimately the decision as the in-house person has to be your decision.
I can confirm that as your counsel, I would not want to be deposed.
I mean, I guess the second area that I would think in that scenario, I've had this where, you know, and this is something for outside law firms really, is that I've had something where they've been told that, well, I've had them report matters to me saying, hey, my client might assert an advice of counsel defense in the case against them. So two things are going to be there. One is, what's that going to do? Because there could be thousands of documents that could just expose them. But then the second thing is, if they're saying outside counsel, I did this because of my outside counsel, now there's probably going to be a claim against that law firm, because what the argument is that, well, I just relied on the attorney to give me the proper legal advice, and they didn't. And therefore, anything that you're accusing me of is really because of my attorneys and the way they represented me. So that's something from an outside counsel sort of scenario where it could be troubling.
Because now you have a related legal malpractice case pending at the same time.
Yes.
Absolutely. So one of the things that often comes up for in-house counsel, particularly those handling claims but not limited to that, is can you communicate with represented parties? So the first question that a lawyer needs to ask is whether or not the other party has a lawyer. And if so, then it's going to be governed by Model Rule of Professional Conduct 4.2. And that will govern situations where the other party does have a lawyer, and it states that a lawyer may not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the attorney has consent. If on the other hand, the other party does not have a lawyer, then that is governed by Rule 4.3, which governs handling of communications with unrepresented parties, which essentially requires the lawyer to remain disinterested and to not provide any suggestion to the unrepresented party that they're providing legal advice or that they could be providing legal advice to the unrepresented party. The reason that this comes up often in the insurance context in a more complicated manner is because it is not uncommon for an insured to reach out to its own insurer to ask questions in connection with their insurance policy. And it's also not uncommon for the claims handlers handling those types of claims to either be lawyers or to be represented by their in-house counsel in connection with those communications. So it raises the question, can an insurer acting as a claims handler who's also a lawyer speak with an insured in connection with the insurance policy, even where a dispute has arisen? So I'll ask you that question and I'll ask you to raise your hand. Can the claims handler, who's also a lawyer, speak with the insured regarding the policy where a dispute has arisen regarding coverage? Raise your hand if you think the answer is yes. Assume they have counsel. I saw some hands go down. So there are a couple hands up and then they went down. Okay, so does that mean everyone else thinks the answer is no? Raise your hand if you think the answer is no.
Nobody wants to.
Nobody wants to really take a position, but there's a few hands going up there. My view is that the answer is, you guys are going to love this answer. It depends. I know, that's a great answer. It's a typical ethics lawyer answer, but the reason it depends is that it depends on whether or not, number one, does the party who has counsel understand and appreciate that they're speaking with you directly and that you're a lawyer, you're not acting as a lawyer in that circumstance, which is most likely the case if you're handling it in a claims handling capacity? And do they consent to speaking with you nonetheless? And does their lawyer consent, which often does happen. So even though there might be a dispute about coverage, there are circumstances where an individual might actually have a conversation with the inside counsel who's actually a claims handler working in a claims handling function with the consent of their counsel, because there's a dispute regarding coverage and maybe they want to handle it party to party, which again, I think most of you would agree does happen from time to time in other contexts and is permissible in those circumstances. Obviously, the linchpin of all of that is that the other lawyer knows it's happening and consents to the representation with their client. And I added on the additional fact that the claims handler in that scenario is acting, although they are a lawyer, is acting in a claims handling function. I know Scott has some thoughts on this because of the professional liability book that you handle, right. And you're talking with lawyers all the time,
yeah,
right?
We talk to our insureds. A lot of our insureds are lawyers, so we're dealing with them, but we can deal professionally with them, with respect to the claim, and then also still not agree on everything. I think as lawyers, we do that all the time. I think that when we're dealing with a situation where there is an adversarial situation, a lot of times I want them to contact me directly so that way it's no doubt that they reached out to me. They're also professionals when you're dealing with a lawyer in a law firm, so they should understand what the terms are in that sense, I think, so a little bit more. I think if you have a less sophisticated insured or claimant that you're dealing with when there's an adversarial position, it gets a little bit more difficult, or I think what Sherry was talking about, I think in those situations you have to be extra careful to not say something or do something that violates the fact that they're represented by counsel. I've had situations also where I'm represented by counsel and I don't want my insured to contact me. So that's something else, because, or in short, or even if it's an independent counsel, I don't want them necessarily contacting me directly, because I've had those circumstances as well. When you have, when everybody's represented by counsel, there's coverage issues, and there are other types of sensitive sort of adversarial issues with your insured. You want to make sure that it's kept at the attorney level. But sometimes, you know, just like any other litigation, party to party, sometimes things get resolved easier.
That's right. Okay. I am now obligated to tell you what the code word is. And the code word is ethics. If you are in the classroom, please write in the column on your attendance sheet the word ethics. If you are attending virtually, type the code word ethics into the Q&A section on the right-hand side of your WebEx screen. And please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is ethics. Okay, I think I've done my duty there. Okay, let's talk for a minute about naming captive law firms. So one of the things that comes up often in the insurance space is that insurers often have in-house attorneys who work just for the insurance company, and but sometimes also handle claims on behalf of the insureds who are insured by the insurance company at issue. And so, first of all, that raises a bunch of different issues that I want to talk about. I won't spend a lot of time on it because I suspect it doesn't apply to everyone in the room, but I'll talk about it for a couple minutes. The first question is, how do you name these entities? The first question is, what do your ethics rules say about whether or not trade names are permitted? Some of the state bars allow it and some do not. What I mean by that, for those of you who aren't sure, is that you can have a law firm and name it after the founding partner, for example, but in a lot of states you can't have something like, attorney's best lawyers, or, California's best, or something like that. You can't use trade names. You have to name them after people or things like that, usually either living people or former partners of the firm. There are a number of ethics rules, though, that govern what types of names can be used. And one of the reasons why why some don't like trade names and want you to use the names of partners is because of the prohibition on using any names that are false or misleading. And if it's named after a person who's currently a partner in the firm, it's clearly not false or misleading. If it's a trade name, sometimes there's some ambiguity there, and the bars often just don't want to deal with that. They'd rather just say, don't use trade names, and then we don't have to worry about it. But what some of the captive law firms have done in connection with their insurance employer is they have used lawyer names, like the Miller & Jones Law Firm. Even though the Miller & Jones Law Firm does 100% of its work for an insurance company, it's paid a salary by that insurance company. So in some jurisdictions, there's been some recent ethics opinions exploring those kinds of situations to discuss whether or not there needs to be a different kind of name used, whether there's any concern about captive names that do not clearly articulate an affiliation with the insurance company. My view on that is that, generally speaking, it's still fine to use a name like that one, so long as the name, the letterhead or whatever else the captive law firm is using in terms of its marketing materials makes it clear of their affiliation with the insurance company, because then there can be no suggestion that the name is false or misleading, or that the affiliation with the insurance company is not being made clear. There are a couple of jurisdictions, including Kentucky and North Carolina, that do not permit captive law firms at all, because they don't want their insurance, essentially in-house employees, representing anyone other than those insurance companies. And part of the reason for that is a very interesting analysis, because what the courts look at and the bars and the bar opinions look at is that when you are an in-house lawyer and you're representing a single company, that's one thing. That's probably like your interests or your loyalties are not divided. You're representing a single employer. When you're in a captive law firm, sometimes you have, number one, you're requested to represent other parties, like I said, insureds. That's one example where there may be a conflict that develops, and then what happens when that conflict develops, unlike us in an outside law firm who can withdraw from one or both representations, much harder to do when you're employed by one of the companies involved. And sometimes captive law firm employees are asked to represent affiliates, like subsidiaries and other corporate affiliates as well. And even where the relationship between the subsidiary and parent is a 100% ownership interest, some courts and bar associations have held that there still can be a conflict of interest between the interests in that particular matter between the two parties. And so it creates some concern about conflicts of interest under Rule 1.7 of the Rules of Professional Conduct. So those are a couple of concerns there. The next topic I'll talk about is risks of unauthorized practice of law. I can say that, like, I used to talk about this 10 years ago and no one cared about UPO because everyone was like, I'm practicing, it's fine. Now all of a sudden, everyone cares about it, including me, because everyone's practicing everywhere, including in your homes and in your vacation homes and at the beach and everywhere else because of the pandemic. In general, almost all the state bars used to operate under this idea that where you are practicing law is where you are sitting. Where is your body located in a chair? That is the place where you're practicing law. There's been some loosening of that over the years, and there's now the bars will look at, what advice are you providing? Who are you providing it to? So if I'm sitting here and I'm providing legal advice to this audience, if I were providing it, which I'm not, by the way, I disclaim that I'm providing legal advice to anyone in the room. So if I were, however, and I was providing legal advice here in New York to this audience, and I was advising under New York law only, would I be practicing law in New York? That's not clear, and I think some of the courts and bars have started to struggle with that a little, have in some ways started to relax their standards a little bit, but we're not seeing it yet widespread in the ethics opinions. So we're not seeing that the ethics opinions are saying, generally speaking, it's okay. There were a few that came out during the pandemic. The ABA came out with one and a few others that basically said, like, it's okay to practice law in these other places as long as you're not strictly providing legal advice on the law of that jurisdiction to clients in that jurisdiction. But again, it hasn't totally been adopted everywhere. My suspicion is that a lot of the state bars want to kind of wait and see what happens, because if everybody kind of goes back to work, they want to be able to protect their own lawyers. Like the bars, the primary reason for UPL concerns, aside from protecting the public, is protecting their own bar and protecting the lawyers within that bar. So I think they kind of want to wait and see what's going to happen, but I suspect that there's going to be a lot of pressure generally from people to be able to practice elsewhere, and we're going to see a little bit of a relaxing of that standard. I see a question in the audience. Yeah, I mean, it's kind of an incongruity with the whole attorney-client privilege, but for in-house counsel, these cases have or Connecticut, like Connecticut, you got to be authorized in-house counsel. There was another, they wanted a $2,000 application fee. I know this because, well, I do. I was in New York, and it's like, no, it isn't. But before that, I was authorized in-house counsel, and I hadn't paid a $70 fee or something. And they wouldn't let me pay it late. And so they kept passing me back and forth from getting work. So I said, let me pay a late fee or pay $140 or something. They wouldn't let me. I was on vacation, and this guy calls me up and says, you're involved in unauthorized practice law. First of all, I don't have a lot of Connecticut business. Yep. And, well, I'm not, providing human advice or anything. Well, I'm not giving advice. It doesn't matter. Anything you do, everything you do is practice. Non-lawyers do it in my company. Yep. Lots of non-lawyers handle claims. It's all handling claims to practice law.
Well, that's...
No way. No way. Yeah.
This guy was representative of the bar. He was like some police guy who was he called me up and said, you haven't, you're authorized. They want me to do the authorized in-house counsel thing again. So they want another $50 bucks. I'll make a little process again. I'm like, oh my God.
Yeah.
And so anyway, to them, going to Connecticut bar, I said, what about people who practice law in New York City and then they come home at night and they look at something like that? They're in jail too,
Yeah. And what year was that? Yeah. So I won't be able to do.
You got out of jail?
Yeah. I won't be able to do justice to that story, to those who are listening in over the audio, over the video, who may not have heard it since it wasn't mic'd, I think. But what I will say is that we have an audience member who was talking about the incongruity between the UPL rules and some of the other bar rules, where if you're practicing law as an in-house counsel, you have the ability to register with the state. In many, many jurisdictions, they don't require you to be admitted in the state and work in-house. It's not true in all jurisdictions, but it's true in most. You can register with that bar. I think Florida doesn't allow you to do it, but many others do, where you can register with that state's bar and then not get admitted there and work in an in-house counsel capacity. And you were saying that you're doing that, but the process is very similar. It's very similar. Yeah, the fee is very similar, and they will get you on the fee. I mean, they make the bars. Are we being recorded? The bars make a lot of money on the registration fees and on the bar dues. So obviously, they have an interest in continuing to enforce that. But I think part of the challenge is that you've got, as you said, claims handlers and others who are doing some of the same work that an in-house counsel might be doing in some capacities, and yet there might be some incongruity there between whether or not it's considered the unauthorized practice of law or not. Yes, unauthorized practice of law for purposes of being house counsel, but it's not practice of law for purposes of so what you're suggesting is that there's a difference between what is considered the practice of law for purposes of confidentiality under the ethics rules, like Rule 1.6. I mean, I think the issue is Rule 1.6 is much broader than the attorney-client privilege. So the attorney-client privilege, as Alana talked about before, only covers communications between a client and a lawyer for the purposes of receiving legal advice. Rule 1.6 governs any confidential relationship that an attorney might receive from a client. So with respect to my clients, I have lots of information that I just know about those clients that may or may not be privileged because it maybe wasn't in a communication, it wasn't in an attorney-client communication, and it wasn't given to me for purposes of providing specific legal advice. But if I were to disclose that information outside of the attorney-client relationship, I would potentially be in violation of the ethics rules and Rule 1.6. So that's why it doesn't always match up, because the standards aren't always the same with respect to what is UPL, what is the attorney-client privilege, and what is confidential. You're touching on another point, though, which is actually, I think, the next slide, which is what about when you're dealing with people who are non-lawyers? Or was it that, yeah, non-lawyers. So there are a lot of parties, individuals who work in corporations and assist lawyers, for example, and who are not admitted to practice law. And I've actually handled quite a few UPL proceedings on behalf of companies, like, for example, companies that negotiate contracts for others who are not lawyers. Like, if I'm getting married, actually I'm already married, but if I were going to get married and I were going to go negotiate a contract for the venue, I would be negotiating a contract. I would not be required to hire a lawyer to do that for me. I could certainly review it and say, no, I don't agree that I'm going to put this huge deposit down or that I lose my deposit. So there are certain functions that I think we would all agree are not necessarily lawyer-only functions. But then when you have a paralegal do it, the question, then some of the bars get concerned about that because they think that it's a lawyer-only function. And so it becomes tricky. I think that in the insurance company realm, there's some very good law out there with respect to what claims adjusters can do. And so that gives us a lot of guidance in terms of like what non-lawyers generally can do, or for that matter, what lawyers can do in jurisdictions where they're not admitted. So for example, claims adjusters can handle claims, they can settle claims, they can even investigate claims. They can't provide legal advice about those claims. So what they can't say is, we should settle this claim because if we don't, it exposes us to a particular risk under such and such statute in such and such state. So we have to be a little careful about that. But your comment was, I think, spot on with respect to nationwide practices. I consider myself to have a nationwide practice. I work in a lot of jurisdictions, and a lot of the advice I give is general to, I'm not providing a state-by-state analysis. And the bars where I'm admitted, one of which is the District of Columbia, I have very few clients there. So I think that the nationwide practice issue is one that I think the bars do understand and respect. That's why I said I think it's a little bit of something we have to think about with respect to, am I providing advice to a client in this jurisdiction on this jurisdiction's law only and like based on experience in this jurisdiction, I think that's generally not the case. If you have a nationwide issue or a nationwide practice or providing advice to a nationwide company that has interests outside of a single state. So hopefully that sort of addresses some of your comments. Go ahead, Scott.
I would just add that, you know, when it comes to adjusters, most adjusters have to be, you need adjuster licenses as opposed to a law license, and they're allowed to negotiate, and also at times, you know, if they use it, they can use a general form for a release if the person's not represented. If you have a $5,000 claim, you know, you're going to want to just settle it possibly and have them, and as long as they're advised of the right to counsel, usually everything's covered. And so you're going to have that situation. But usually as an adjuster, even if you're a lawyer, you don't need to be a lawyer. It's more important that you have your adjuster's license, and those credits are paid for and up to date.
Yeah,
that's exactly right.
And one other factor too, from the opinions that have come out during the pandemic about unauthorized practice, focus too on how you hold yourself out to the community. So especially for people in metro areas, you live in New Jersey, you work in New York, you live in Virginia, you work in DC, it matters how you hold yourself out to clients. So for people who were working from home during the pandemic, the bars were advising them, you know, don't put your home address on your letterhead if you're not admitted in that state, because a reasonable person would look at that and think, oh, here's a Connecticut lawyer. But if you keep sending things on your, even if you ask someone to send you something, have them send it to you at your New York office and have your New York office send it to you at home. Because if you're telling someone, send it to me at home in Connecticut, they may reasonably assume that you're a Connecticut lawyer. So this next slide covers some of the unauthorized practice of law issues relating to claims adjusters.
I think given the time, let's jump ahead to, why don't we jump ahead to claims handling and the tripartite relationship?
Yes, let's do that.
We only have about 5 more minutes, and then I want to leave a little time for more questions. So let's talk a little bit about what is the tripartite relationship. So the tripartite relationship is the doctrine of law that provides a joint access to privileged information between the 3 parties listed on the screen, the attorney on the one hand, and the insurer and the insured. So this is a situation where, let's say, a single attorney represents both the insurer and the insured in litigation. In that scenario, technically, the attorney represents the insured, where they've been hired by the insurance company to defend the insured. However, there's a whole body of case law that essentially says that the insurer is entitled to access to information regarding the representation, and that disclosing information to the insurer is not a breach or waiver of the attorney-client relationship. So they can still get that information, and it protects the attorney-client relationship so that opposing counsel in the litigation can't say, well, wait a minute, you gave that information to the insurer, so now I get access to it as well. So a number of the jurisdictions out there dealing with the tripartite relationship say that the attorney essentially has an obligation to both parties, but that the insured is the primary client. So conflicts have to be resolved in favor of the insured. Now, there's a lot written out there about this, you know, conflict situation or issue, and whether or not the attorney, who very often is a repeat provider of services to the insurance company, really is loyal to the client versus the insurance company. And I'm sure, Scott, that you have some experience with the tripartite relationship and can comment on that.
So obviously, when an insured is, look, we have insureds that we have claims against, and we hire an attorney to represent that insured. Now, that attorney that's representing that insured has to, well, what I need to do to evaluate my claim is I need information from him. I need to be able to look at the file and be able to understand what happened here. And there could be communications that I need access to that maybe are attorney-client related that we would not, that the other side shouldn't have. And I think that they've made exceptions for that, and therefore, so we're able to properly evaluate our claim. You know, if we don't get the information that we need, we can't evaluate, we can't set reserves, we can't try and resolve it with all that information. And if you just give it to, and if the insured and his attorney are the only 2 that have it, it really would put us at a loss. And I think that's why they have the tripartite relationship.
Now, in contrast to the tripartite council, there's also an attorney in California, they refer to it as Coombs counsel. In some other jurisdictions, they refer to it as independent counsel. Those are circumstances where a conflict of interest develops between the insurer on the one hand and the insured on the other. For example, with issues regarding coverage. Let's say hypothetically that the insurer has issued a reservation of rights or a partial coverage denial. Then in that scenario, can you have the same lawyer representing both parties? The law typically says no. As soon as a conflict develops, then the insured is entitled to independent counsel, which in California is referred to as Coombs counsel. And nonetheless, there is still information that the insurer is entitled to, even in Coombs or independent counsel circumstances, because the insurer has an absolute right to evaluate information relative to the claim, the value, and its exposure or potential exposure. And so in that scenario, it simply would be unfair if the party representing the insured could withhold information from the insurer and yet expect that at the end of the day, the insurer was going to pay the ultimate liability under the policy without access to complete information. So most of those states say that as long as the information doesn't bear on the coverage issue directly, the insurer is entitled to that information, and it's, again, protected by the attorney-client privilege. Anything to add on that, Scott? I know we're right at the end of our time.
Sure. I mean, it's because I think and the reason why they do the independent counsel is because the courts feel that attorneys may have more loyalty. If attorneys are panel firms, they might have more loyalty to the carrier as opposed to the insured. So now the insured gets to go and pick his own attorney who represents solely his interest and not the carrier's interest. And so in those scenarios, it becomes a little bit more difficult. But at the same time, like Sherry said, we're entitled to certain information. We still have to be able to evaluate the claim. And it's just that so that the insured is guaranteed that it's his attorney, not that they don't have loyalties to the carrier.
Absolutely. Okay, I think we're right at the end of our time, but I think we might have time for one or two questions if you have any.
Yes, hi. There was one question that came through in the chat. I think this was during the unauthorized practice of law portion. So an attendee asked, could you comment on the ethics considerations involved with the role of a reinsurance intermediary and its ability or inability to draft contracts on behalf of cedent clients?
By reinsurance intermediary, do you mean like a broker or like an independent party that would provide contract services?
Broker.
Okay, so can you repeat the question again?
Sure.
Yeah.
The ethics considerations for the role of a reinsurance intermediary or broker and that person's or that entity's ability or inability to draft contracts on behalf of their cedent client.
My experience with UPL issues is that whether a party can draft contracts depends on the complexity of the contract and the extent to which legal analysis is required. So, like I said, there are some companies out there and their business to some extent is, I mean, hotels draft contracts all the time. Again, simple contracts where they kind of look the same and they're copy pasting a lot of information from one to the next. If you're talking about sophisticated contracts, it depends is the answer. I know that I always hate to hear that answer myself, but underwriters draft contracts. That's what they do. They prepare insurance contracts, and that's part of the reason why the regulators are so heavily involved in the insurance business, because they want to make sure that the contracts are also benefiting the insureds and that you don't have these massive organizations drafting language that's not good for the public. So it's a little more complicated. It's a lot more complicated, frankly, when you're dealing with insurance contracts than it is in a different scenario where you're talking about, you know, the kinds of examples I've just given, like, you know, a hotel that's, can they draft their own contract? Probably. Can a reinsurance broker draft a contract? Sounds to me like the kind of situation that would be very law intensive. And so my gut says be very careful in that scenario.
And too, if they have templates that they're working from, as Sherry suggested, that when we're dealing with the opinions that have dealt with similar issues, say, if you're just cobbling together terms from existing contracts that lawyers drafted, you're likely not practicing law. Exactly.
So I serve on the New Jersey Supreme Court Committee for the Unauthorized Practice of Law, and we get a ton of questions raised in transactions. Yes, it sounds like we should have a conversation. A lot of questions in the transactional context because it's a little harder to predict or to understand what the unauthorized practice of law is when negotiating contracts. So we do get a lot of questions on that.
What I would say is there are a lot of bar opinions out there in the various bars, and they are not consistent. I have seen things in some jurisdictions that were permitted that were absolutely not permitted elsewhere. So it's really important to go back and look at the ethics opinions because some of them provide a lot of guidance on what transactional lawyers are allowed to do and the extent to which they're allowed to rely on non-lawyers and assistance with contracts and things like that. So always look at the ethics opinions if you have questions.
We have one more question from the chat. Very interesting question. Can an insurer refuse to hire an attorney chosen by an insured if the insurer reasonably believes that the attorney is not suitable to handle the case?
Yeah. Yeah. Absolutely. Yeah. Absolutely. I mean, it says in section C of the Coombs statute, and which is obviously California, but there's a number of similar rules outside of California.
This is like the seminal case, but then a lot of people copied it.
Yes, a lot of other states have copied it, but it basically includes language saying that it has to be an attorney who is qualified to handle that type of matter. Now, obviously, that creates a real fact question about what qualification means. This is something that we've seen before where we were trying to, analyze, is this person, do they really have the right experience to handle this matter? Because they might be really sort of the go-to friend of who happens to be a lawyer, and that's really tricky. And so
you get that a lot.
Yeah.
That's where you get it a lot, is you get somebody who wants to hire their buddy who does real estate closings to defend a legal malpractice claim involving intellectual property. You're probably not going to think that that person's appropriate to defend that particular case.
Unfortunately, they're not always that easy.
Yeah.
Sometimes there's
a lot of closer calls.
Yes,
too,
exactly. Yeah.
And under the statute, too, the insurers may also have rights to limit the fees that are being paid to what they would pay lawyers in that industry if they were hiring their own counsel directly.
Okay, with that, thank you, Sherry, Alana, and Scott for that very informative presentation. I think we've satisfied our ethical obligations for today, maybe.
The word is ethics.
The word is ethics for your keyword. We have a quick break, well, actually a slightly longer break till 3:25, and then we're going to come back for the COVID-19 case law presentation. Thank you.
We're here this afternoon to pick up discussing COVID-19 case law updates and impact on future insurance litigation. I'm Julia Beckley, counsel in the Dallas, Texas office.
Douglas Stewart. I am with the Toronto office, so on the Canadian side, partner in that litigation group, and do a lot of insurance work with my U.S. colleagues.
And I'm Erin Bradham, joining remotely here today. I'm sorry not to be there in person with you all, but I am a partner in our Phoenix office, Dentons Phoenix, in sunny Arizona. And for the last 3 years or so, I've spent a lot of time thinking about the topic that's for our presentation today, which is attempts by policyholders to recover for COVID-related losses under commercial property insurance policies. So the way we're going to proceed today, and I'm hoping the IT folks can put up our presentation. I'm at least not seeing it. Maybe you can see it on your end. But the way we're going to proceed today is Julia's going to start us off, and we'll talk through where we are with this litigation. It's really an interesting story in terms of just the volume of litigation and what's happened, where we are with the litigation, and the current status, and then in the United States. And then Doug is going to talk through where we are with this similar litigation and current status in Doug and in Canada. And it's been actually a fairly different trajectory. And then finally, we're going to talk through lessons learned, what we've learned about judges and proclivities and the way litigation can run and the things that can be important through this sheer volume of litigation we've seen, as well as potential impacts in the future of having all of this case law that's now been developed. So I'm going to turn it over to Julia.
So what we've seen at the beginning of the COVID pandemic is companies started suffering economic losses, and they decided that one of the ways they could recover those losses is by trying to collect on their business interruption coverage in their commercial property insurance policies. So they were trying to recover the economic losses under property insurance. And there has been a tremendous amount of lawsuits on this filed. More than 2,000 suits were filed in the U.S. seeking coverage for the COVID-related losses for business interruption. There have been cases filed in nearly every jurisdiction in federal and state jurisdictions in the United States, and almost 900 decisions. 90% at the trial court level have rejected this coverage for COVID-related losses. And we now have more than 125 decisions at the appellate level. More than 125 have rejected such claims and only 3 unfavorable, which Erin will get into in a few moments. So there have been 2 main theories that policyholders have used to try to obtain this coverage. The first is the use it or lose it theory, which is the overarching government orders shutting down businesses, telling them they couldn't operate their businesses or not allowing their businesses to continue on a temporary basis, as well as extension. So we've seen government orders in nearly every jurisdiction in the United States shutting down or limiting business in some regard. So the policyholders started a theory on the use it or lose it basis that they suffered direct physical loss or damage because they couldn't use their property. However, it doesn't say direct physical loss of use or damage, it's direct physical loss. So they're not actually losing or suffering any damage if there's only loss of use. And this would have been very problematic for the insurance industry, as this would be a low burden for policyholders to show. They could simply show there was a government order preventing my business from proceeding, and if that was all that was needed, they would prevail on this. For example, perhaps a hair salon has to shut down by government order, so they're not getting any income from that business for as long as the government order shuts down the business. The good news is that courts have been dismissive of this theory early on at the motion to dismiss stage. So this is a bigger departure from existing case law. And this has been universally rejected by the appellate court. So what we saw is as this case law was established, policyholders changed their theory away from the use it or lose it into what we call more the mold analogy, claiming that the physical presence of COVID on their property is causing direct physical loss or damage in the way that mold or some other particle on the property might do so. Now, this is a harder burden on the policyholders to show that if they had a number of locations in their policy that each one had physical COVID present on there, and that any lost, any business interruption, any losses were actually due to COVID being on the property. So some plaintiffs and policyholders intentionally avoided this theory. It's also, for an additional reason, some policies have a virus exclusion or other exclusions based on biological pathogens, viruses, or other exclusions that would cover something such as COVID-19. So even when a claim survives dismissal, it's a difficult path to recovery because you do have to show that the loss is due to the physical presence of COVID on the property. Now, the decisions that we have on this have been nearly unanimous in rejecting these theories of COVID-related losses. There's no appellate court anywhere that has sanctioned recovery under the loss of use theory from government orders, and all but 3 have rejected the presence of COVID argument, the evanescence argument that a COVID particle does not cause direct physical loss or damage. But there are exclusions that apply to preclude coverage for viral contamination. Erin's now going to walk us through some of those outlier cases where this theory were not rejected.
Thanks, Julia. If we could advance to the next slide. There we go. So there's been, as Julia said, a number of favorable high court decisions that have rejected these theories. There's been now only one unfavorable high court, state Supreme Court, highest court in the state decision, and that's in Vermont in the Huntington Ingalls case. But that decision was really still fairly narrow. The court did not accept that use it or lose it theory that Julia talked about, that really what would have been and was what people in the industry most feared when all of this started, that simply having a government order closing you down would be enough. The court, in fact, expressly rejected that theory. And the case is really about the pleading standard. The case really says, look, you can get there if you plead that COVID causes an impact on your property, causes a tangible alteration to your property, then that's really something that has to be decided on the facts and can't be decided at the pleading stage. We'll talk a little bit about how other courts have dealt with that. But it's a fairly limited decision, and there's still a road for the insured to have to go down in order to ultimately recover, which is showing that COVID did in fact have an impact on the property, create some kind of tangible alteration to the property, or otherwise an impact that could be considered direct physical loss or damage. The exclusion that Julia talked about, a virus exclusion, was not at issue in that case, so it didn't address that. And it was a bit of an unusual fact pattern. Rather than having the normal scenario where you have a restaurant or a hotel or something that's forced to close down because of COVID, this was actually an essential business, a shipbuilding business that was allowed to continue. And so it's easier maybe to fit in to that theory that Julia talked about, the mold analogy theory of presence on the property, than it would be for a restaurant, say, where the fact pattern would likely come out as, well, they closed when the government told them to, they reopened when the government said they could, and they probably had a lot more COVID on their property after they reopened than they did in those early days of COVID when things closed down. And it, an interesting thing is we thought that if, or at least, a lot of people, I think, thought that if one of these Supreme Courts held in an unfavorable decision on this issue, that you'd sort of get a flood of litigation to that court. We're tracking the litigation, lots of people are tracking the litigation, and we haven't really seen this sort of flood of litigation in Vermont. Perhaps part of that is that it's a smaller jurisdiction. There's going to be less policies, less policyholders. But a piece of that as well, I think, is just the fact that this really was more of a narrow decision, and it's still unclear whether the insured is ultimately going to be able to prove what they what the court would require them to in order to recover. So going on to the next slide. The second of the unfavorable appellate decisions is from the Louisiana Court of Appeals. So this is an intermediate decision. It's not the high court, but it's much more comprehensive and problematic from the insurer's perspective than the Vermont decision, because it didn't just rely on pleading standards. The court said that coverage was actually established. But again, it did that through that, what Julia called that mold analogy. It did that through looking at cases that had to do with lead paint and drywall and other substances on property. So even it didn't go so far as to accept that government orders are alone theory that Julia talked about. But the court did make a number of other decisions that most of us think are questionable, including this notion that the continuous presence of COVID, people coming on and off of the property, could be property damage, even if you're not sure that you had COVID on the property in any particular instance, and could clean it quickly. This was actually a decision not at the pleading stage. There had actually been a trial, a bench trial. The verdict went for the insurer, and then it was overturned on appeal. So the case doesn't rely on any of those, we're just at the pleading stage kind of arguments, and is really at the end stage post trial. So it's a much more problematic case. There has been some litigation that's picked up in Louisiana, or policies that would apply Louisiana law, but there really hasn't been that flood of cases in Louisiana since the decision. And that's likely due to the fact that it's just an intermediate decision at this point, and that there's some question about whether the Louisiana Supreme Court will ultimately go the same way. It's a divided decision, and there's some question about what the Supreme Court will ultimately do. The federal courts looking at this particular case have actually said, although we're required to apply state law, we predict that the Supreme Court will not go the way of the Intermediate Court of Appeals, and will actually go the way that other high courts have done. So it's a bit of an interesting scenario where the federal courts are saying, yes, we see the appellate law there in Louisiana, but we don't think that's ultimately how it's going to play out. The third outlier case is in California, and it was similar to the Vermont case. It's really focused on the pleading standard, so it's not that particularly problematic case like in Louisiana. And there have been a lot of favorable appellate cases in California as well. So most of the trial courts have said, we want to follow the majority, the favorable, and have not been willing to follow that one unfavorable decision there in California as it's played out so far. So this litigation continues, despite the fact that you saw in Julia's slides, there's really overwhelming litigation in favor of insurers. The litigation continues. And why is that? Well, because there's venue and choice of law issues trying to get to jurisdictions that either are these outlier jurisdictions like Louisiana, or where there is a thought that they might become outlier jurisdictions ultimately. A few of the jurisdictions to watch are Texas, where judges are elected. There are very few state court decisions on these issues in Texas because of the procedural rules in Texas that make it harder to get a decision pre-trial and particularly at the pleading stage. And so Texas is certainly one to watch. There's at least one appeal up before the Texas Supreme Court, or in the appellate process right now. Then Nevada is another to watch. Again, elected judges, and we'll talk in a bit when we talk through the lessons learned about why that matters, and we've learned that it matters a lot. And so there again, we have state court decisions that are unfavorable. We have federal court decisions that are favorable and are predicting that ultimately the Nevada Supreme Court is going to join the other Supreme Courts in rejecting these theories, but certainly one to watch. And then Colorado actually has a lot of unfavorable state court decisions, and so I put that on the jurisdictions to watch list as well. So moving on to the next slide. We'll move on to
we've reached that time with your code. As mentioned at the beginning of the program, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All New York, New Jersey, Pennsylvania, and Kansas licensed attendees must fill in the code word. If you're in the room, please write in the appropriate column on your attendee sheet. If you're attending virtually, type the code word litigation into the Q&A section on the right-hand side of your WebEx screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is litigation.
Thank you, Julia.
And now we can turn it over to Doug, who will discuss the Canada decision.
Thanks very much.
Thanks very much, Julie. So COVID did spread to Canada, and we did also have a number of claims filed against insurers for COVID-related business interruption losses. The main difference is we do not have a cadre of decisions that really have come out yet directly dealing with the issue. There are a number of actions, including notably class actions, that are proceeding through the system, but nothing near to the extent of what you will see here. And I would say for the most part, it's going on in the province of Ontario, which is where I'm going to focus on. I'll also comment that the summary judgment motion practice in Canada is not nearly well as developed and forward-leaning as it is, I should say, in the U.S. So as a result, you know, no one's been bringing these motions for summary judgment on the claims, not meaning that they potentially couldn't be successful, and there is a process going on one of the class actions, which is sort of akin to it. But that's one of the reasons why you actually don't see many decisions right now. So in that regard, there is a notable proceeding going on right now where it's going to be going to a hearing on some of these sort of gating issues, I would say, early next year. The gating issue, I would say, which is key, is whether or not COVID amounts to physical loss or damage. That hasn't been directly opined on yet by a court. So there's a series of class actions brought across the country in various provinces. We call them the omnibus class actions because essentially they were targeting a very broad group of class members as opposed to more targeted class actions, say, on behalf of, you know, nursing homes, for instance, which are proceeding. So these ones were on behalf of a very broad class, filed against a number of insurers across the market. The actions were stayed in the other provinces in favor of Ontario proceeding to avoid a multiplicity proceeding. The interesting procedural aspect to this, which is called the workman proceeding, is that it was being case managed. I won't name the judge, but there was concern amongst the insurers' council that perhaps we weren't going to get a fair shake before that judge during the certification process. So seeing the writing on the wall of where his proclivities lay, they worked out a process with class counsel to agree to have the determination of certain issues transferred to the commercial list where you have a certain high caliber of judges available. But the quid pro quo was we had to agree on certification of certain common issues. And those common issues we've sort of highlighted there, and those reflect what I call the gating issues before you get into other considerations. Most notably, the first issue is whether the presence of COVID virus or its variants cause physical loss or damage to property with the meaning of business interruption provisions. Will this obviate all claims? No, but if it goes the right way, it'll obviate most of them. And this is an issue carefully picked, obviously, because we're well aware of what's going on south of the border. While it's not binding, it's going to be highly persuasive. I'll also say that, you know, people have paid attention to what went on in the UK with the FCA hearing, and the fact that they didn't even consider physical loss spoke of itself, that really wasn't an issue worth considering over there. So this is one of cautious optimism that the insurers are proceeding to a hearing in February. The other ancillary issues they're looking at are noted there too, whether orders of civil authority or its variants cause physical loss or damage, and if the answer to either one of those is yes, then whether there are any exclusions. There are a lot of common exclusions that can be an issue of these policies. So as mentioned, that's proceeding to a hearing. I understand there's going to be extensive record, including expert evidence, and it's been closely monitored and is expected, quite frankly, to clear out the system, probably with a lot of claims. We can move to the next slide. I decided to include just a little write-up on this decision, CerCorp via Viva. This kind of went along quite quickly, which is unusual in Canada. Litigation moves slowly. But this was an application, so just to be clear, proceeded entirely on a paper record, which allows you to move forward more quickly. Interestingly, there was no expert evidence, but essentially it was an application brought by Surcorp, which manages a number of restaurants across various provinces in Canada, which obviously allegedly suffered business interruption loss due to the close down. They were relying on the all-risk nature of their policies and essentially taking the view that that provided very broad coverage. Now, the interesting part of that is they are saying that the court doesn't even have to get into the whole physical loss or damage trigger because they're primarily relying on special endorsements and extensions of coverage, which I've noted there. The wordings are always a little bit different between each policy, but generally speaking, the idea that civil order or military authority has caused a loss, interruption by civil or military authority, or ingress or egress prevention into the premises. So these are the three sort of main areas that they're relying on, and those were litigated over the course of several months with interruptions in the hearing. It's unusual. Usually an application's heard in a day or two. This occurred over the course of 5 different appearances, I believe, till December. So the hearing's finished. We're still waiting on a decision. Decision hasn't been rendered yet, which is unusual. There's some speculation amongst the bar that perhaps it's soft pedaling because they're aware of the larger process of workman going on. But that's just pure speculation. But you know, this decision could be quite pertinent because of course, the insurer does say there is a physical loss or damage trigger. So to the extent that the court needs to deal with it, they may have to, you know, opine on that. There are other issues being determined in that proceeding, such as the removal of an earlier microorganism exclusion, which creates an inference that viruses are peril insured, which actually, you know, I think caught that particular judge's attention. So we may hear something about the impact of exclusions and removal of them. Just want to move to the next slide. This case I've included MDS was a decision from our Court of Appeal reversing a decision that came out in March 2020, nothing to do with COVID, but to do with the court's interpretation of physical loss or damage. It caught great interest from the plaintiff's bar. There were articles written saying this is opening the floodgates to COVID, which upset a lot of insurers up there. But you know, most defense counsel said they're overreaching, which I think is the case. That particular decision dealt with a claim for loss of profits caused from the shutdown of a nuclear reactor due to corrosion. And the insured suffered economic loss due to the interruption of supply of its radioisotopes. Now, there was a section to the exclusion of the policy, excluded corrosion, but if physical damage not excluded by the policy results, then that could be covered. Now, the trial judge found essentially for coverage on the basis that the economic loss fit within the scope of physical damage, which, you know, I think ran contrary to some decisions in other provinces in terms of the scope. And the Court of Appeal did jump in and correct that and basically said, you know, as I noted there in the slide, where policies intended to include not only physical but economic losses, insurance policies specifically define property damage to include the loss of use. So it is open, but it depends on the policy language, and most policies don't include that language. So they did rein that in. And when the Court of Appeal was looking at this and hearing argument, they were well aware of all of the cases that had now been started around the COVID business interruption. So this has been widely viewed as the court signaling its likely views on reining in some of the arguments about the scope of physical loss or damage. That is expected to be actually quite significant in terms of any future cases relying on the scope of that language. And in fact, we've actually seen that now play out in terms of the impact of NDS. There's one case that came out very recently, not in the insurance context, but a COVID-related case dealing with a claim by a landlord for rent arrears, and the tenant was a gym. And obviously gyms have been greatly affected by the pandemic. But essentially in that case, the gym owners were arguing for a rent abatement because they said that the COVID constituted damage or destruction. And there was a provisional lease providing for this. Now the provisional lease did require damage. And expert evidence was tendered in that case. opining that the COVID's contagious spread and high risk in gyms made the equipment unusable. The landlord argued, as we can expect, that it was a government orders to close the gym, not the presence of COVID. There was no evidence of microscopic damage. So they got right into the issue of, the effect of the virus and also whether or not it amounts to physical loss or damage, because there was a provision in the lease providing for that. So the court agreed with the landlord, found there was no evidence that the building or exercise equipment was materially altered by the virus. And I've actually included a provision from the decision there, which I imagine is going to be heavily quoted in any future cases, and basically highlighting that the virus is inert. It does not harm the building, but harms persons using the fitness equipment. The gym is closed by government orders to prevent harm to people. So, I would say arguably a common sense approach to this. So that's been quite heartening. And quite frankly, on a personal level, we've already seen the effect of that, with some plaintiffs coming and asking, can you just give me anything to get rid of this claim, because they're starting to see where this is likely going to end up. In that decision, interestingly, the court did rely on the MDS decision on the Court of Appeal. So it looks like, that Court of Appeal decision and probably the intention of the appellate panel to signal where they're going to starting to have an impact. I will note as well that the judge in this case, Niagara Falls, did rely on some U.S. decisions as well, so it shows the impact of what goes on south of the border. So that, by and large, is what's going on in Canada, and yeah, there's going to be some significant developments next year, although everyone is trusting it will probably go in the way that we've all been seeing it develop, like we've seen it here south of the border. But it's going to go up to the Court of Appeal, potentially Supreme Court, so this could be litigated for a few more years. And so we're not going to see the last of this for a little while.
Very good. So we're now going to talk through, all of this litigation that we've seen in the US at least, and also in Canada. In my experience, at least, this is an unprecedented sort of a litigation phenomena, that you have this many cases being litigated where there really aren't a lot of factual distinctions that at least have made a difference, and they're being litigated in every jurisdiction over the course of a relatively short period, with the different jurisdictions weighing in. And so there's a few things I think we've learned about judges and litigation and how this all works, from having seen this play out. The first and maybe the most important is that the rule of law has mostly been upheld. And I think many folks in the industry were worried when this all started that that wouldn't be the case, that it seemed like a bit of a perfect storm of sympathy and sympathetic insureds. When this litigation began, the earliest cases were brought by the small businesses. The mom and pop restaurants were a big part of those earliest cases. And so these were people, and we were at that time early in the process of COVID. People's lives had just been dramatically impacted. These were businesses who, through no fault of their own, had their livelihood, their kind of reason for waking up in the morning and doing what they do interrupted, and that seemed like such a force that any judge would be looking for some deep pocket to help these insureds, and would be sort of looking to take every liberty they could with the language of the policy, and really to have outcome-oriented, determining reasoning, rather than actually looking at the policy language and working through these issues. And that, for the most part, hasn't happened. As we talked through, we have these outlier cases, but apart from the Louisiana case, the Vermont case, the California case, you don't read them and get the feeling that these are judges who have just taken off their call to fairly evaluate the cases. really, apart from the Louisiana case, that's the only one you kind of read and get the feeling like something else is going on here, and this is sort of an outcome driven analysis. So that, in my mind, is just a surprise, and a big surprise, that we didn't have more outliers at the trial court level, that at the appellate level, the courts really have been applying the law, applying the contract. Certainly judges have been sympathetic to insureds, and many of the cases say we're sympathetic to the insureds, but we've got to enforce the contract. But it almost seems like what's happened is the judges really realized this was overreaching, just at a gut level, just thinking about what a property policy is meant to be, that it's meant to be fire and hurricanes and tornadoes and all of those things that you think of when you think about commercial insurance. And that the judges really saw that as a sympathetic insured doing what they could, but that it really was overreaching arguments. And so we've seen, for example, judges being willing to apply their common sense in a way that we might not have predicted at the beginning of all of this. At the beginning of all of this, we thought the use it or lose it theory Julia talked about, the I can't use my property, the government shut me down theory, that would be one that really works very well at the pleading stage. But the COVID's presence damages property theory, it seemed like maybe that would be a little harder at the pleading stage. Maybe the courts would say, look, that's really a fact issue. Let's get the experts in here, as those few courts in Vermont and California have done, or that the courts would say, look, you say COVID can be cleaned, but we've got to play that out in front of a jury. We've got to play that out and see how that goes. And so I was personally surprised at how willing courts were to essentially apply their common sense, and not to say, well, look, as a formal matter, we've got to put this in front of a jury, or at the very least hear evidence and be deciding this at a summary judgment stage. I think a part of that is that there's something unique, another thing, just in addition to the scope of the litigation, something else that's unique about this litigation is that we all really have lived it. So the judges we're arguing in front of, the lawyers who are making the arguments, have all lived these issues. They've all seen what happened. They all know why the restaurant closed down, and they know it was because the government ordered them to, and they know they saw the "We're back open" sign in all the restaurants when the government said that they could reopen. And people know, just as common knowledge, that COVID doesn't disintegrate the drywall or become embedded in the drywall like mold does, and people know as common knowledge that there was probably much more COVID on the property once businesses were allowed to reopen than there was in those early days of the pandemic when the orders came out, where in many places, COVID hadn't really spread very far at that point. So all of that common sense, the judges have been willing to apply. And I think that part of the reason they've been willing to do that is because they did see this as overreaching, not in a nefarious way, again, sympathetic insureds, but they really saw this as just so far off base from what these policies were really designed to do. So the big story in my mind about the lesson we've learned about how this played out is that the rule of law has mostly worked. And I think there was a good deal of fear that it wouldn't work as well as it has so far. One of the things we've also learned is the big difference between elected judges and appointed judges. As we've seen in particularly the trial court outliers, there was a much higher percentage of those outliers that were from elected judges rather than from judges who were appointed. And as we've talked about, the real cases to watch and to be concerned about are in those states where the judges are elected. And that political pressure point is perhaps the bigger thing than the jeopardizing a fair application of the law than the sympathy pressure point that at least many people thought we were really going to be facing, which I suppose is perhaps the cynical take on what's happened, that when it is perhaps that self-interest is trumping sympathy to others, but certainly we've seen that play out with elected judges versus appointed judges. Another thing we've learned here, and that I think was a surprise, is that this process really wasn't driven by class actions and mass actions the way we thought might be the case at the beginning of this, and we're planning for how to defend against those kind of actions. Part of that is just that the cases got sort of cut off before they got to that stage. But I think part of it as well is just the fact that each one of these insureds had a bigger stake in this. And so plaintiffs' attorneys were willing to say, well, I want to take this as an individual action rather than to try to group them all together. And I think that might be part of what we've seen in terms of that interplay with the sympathy, because there wasn't really a place for the courts to go to split the baby, as they say, in analyzing these things. The amounts being claimed were often very, very high. And so it was really that kind of either or that I think contributed to the judges saying, well, we really do have to apply the contract as it's written, and seeing it as maybe a bit of what would have been a bit of an overreach in terms of the general intent of these types of contracts. So now that we've got all of this case law that Julia talked about, the question becomes, is that going to change things in the future in dealing with other cases, other scenarios, not COVID-19, but other scenarios after we finally move on from this litigation, other scenarios that are dealing with that similar direct physical loss or damage language. And so I'm going to turn it over to Julia to talk about that.
Thanks, Erin. So in evaluating what the pre-COVID legal landscape was like, property damage was pretty clear. It could be a fire or a hurricane or an earthquake or some storm damage. And there was no real question as to whether or not those were considered property damage. And for that reason, the case law wasn't well established on what direct physical loss or damage means. Now we have case law in almost every jurisdiction, if not every single jurisdiction, as to what is direct physical loss or damage. And it's in a meaningful and detailed way, instead of conclusory, like you have a fire that causes damage. Now we have to dissect what those words mean that often aren't defined in the policies and ask what they mean. And so what we did have is a little body of case law on it, and it was growing, that suggested that the semi-tangible particles harmful to humans, such as asbestos and bacteria, could constitute direct physical loss or damage to property if the presence of those substances made property uninhabitable. And so there was a big concern based on that body of case law, what would happen with something like COVID-19. And we're pleased to say that it has come out well for us, and it now the body of case law is that most jurisdictions require a tangible alteration to property in order to be considered direct physical loss or damage. So the mere presence of intangible particles on a surface isn't enough. And loss of use, as we discussed with the use it or lose it, is not enough either. Yes, yes. But it's considered different than asbestos or mold, and this is a good distinction that we found in the case law because both of those can be fixed or remediated, and they actually might go and damage the property. So mold, you can look at mold in a desk, for example, and the desk is damaged due to the mold. If you've seen anything, an article of clothing, a piece of furniture, the mold actually damages it. You can take that piece of property away, or you can fix it, and then the property is fine. What we have with COVID-19 is a little distinguished because it's not damaging. If you have COVID-19 on your desk, you're not damaging the desk. The desk is still fine. You can wipe it down and sanitize it, and your desk is still usable. You don't need to replace the desk, for example. So the courts have distinguished it and gone away from that definition, such as for other particles that we've seen in the past. So this is suggesting moving away from the prior way of thinking. So I think this actually goes directly to your question. It's almost as if you anticipated what we were going to say, but the move away from mold or asbestos, which actually might damage the property, is we've stopped that trend. You have another question? Well, but is it a property loss? Is it a direct loss of some property? It's not loss of use. The courts have made that clear that it's not loss of use. It's property damage, physical loss or damage. So you're not losing the desk and replacing it. You're not, the desk isn't damaged such that you can replace the desk, and it's not loss of use. So that's right. Yes. No, you're correct. There is loss of use. However, that loss of use is not direct physical loss or damage. It's not covered. That's right. So our big takeaway is that this has stopped the trend towards the expanding coverage for these particles. And you already kicked us off to a start, but we're now like to open it up to any questions that others might have or that we've received online from, yes, Tomasita.
That Louisiana case, did they have a virus exclusion in that one?
I think Aaron will talk about Cajun County and whether there was a virus exclusion in that one.
And I think that was my friend Tomasita, very good. There was not a virus, so that's a very good question. There was not a virus exclusion in that case. And the court actually says, look, the fact that they didn't put in a virus exclusion, knowing that there was some pre-COVID case law in Louisiana that said, that pushed toward an expansion of the concept of direct physical loss or damage, was one of the things the court cited as particularly persuasive to it. That the idea was, look, you knew that in Louisiana we had this pre-COVID case law, kind of that trend that Julia was talking about toward expanding direct physical loss or damage, and you should have put in an exclusion in that context. So that's very important. The result may well have come out differently had there been an exclusion.
Erica, did we receive any questions online for this one? No. All right. Well, then I'll pose some questions maybe to Erin so she can answer some more. But how long is this litigation going to go on? Are new cases still coming in, Erin? And what is the future of this litigation? How much longer can we anticipate these cases to be decided?
That's a question I've been asking myself since March of 2020, Julia, and every maybe 6 months I say, there's probably only, 2 months more of this and it's going to be wrapped up. And that of course hasn't happened yet, but what has happened is it's very much started to slow down. So when you look at, and there are online trackers, our firm tracks this, but folks track it online as well, in terms of the volume of cases filed on this issue. There was a huge surge just before the last anniversary, last March, as people were trying to get in under statutes of limitations and limitation clauses and contracts, and then a big drop off. But we're seeing cases continue in those outlier jurisdictions where the plaintiff's bar still has a hope that they might end up with an outlier scenario. And so it's continuing, but it's continuing in a smaller volume and more focused on discovery. And the big question in many of the cases is whether the cases are going to get stayed pending appellate decisions. And it's interesting because you have the policyholders council who very much don't, in many instances, want to say that they really want this case stayed pending the resolution of the appellate cases, but you get the feeling that that's what they want, because in some instances they're not driving them forward in jurisdictions where it's still a question mark as to whether, as to how the courts are going to come out. So that's been kind of an interesting phenomenon that nobody really wants to. In some of these cases and in some of these jurisdictions, the policyholders don't really want to invest the funds to keep going because they know it's a big question mark if it'll ultimately be useful, but they want to hang in and see what the courts have to say on the chance that they end up being in an outlier jurisdiction. And then we've seen intense litigation in ongoing in Louisiana and in other states where people have a thought that there's a good chance that courts could ultimately depart from what's generally been done. Very good. Any other questions? Well, thanks to everyone. I think that takes us to the end of, just about the end of our time here.
Thank you, Erin, Julia, and Doug. That was great. We will take a quick 5 to 10 minute break and come back for our last session updates from the NAIC.
To the last session before the cocktail hour. This is the regulatory updates from the NAIC. During the session, we're going to preview the newly formed NAIC H Committee and its initiative. We're going to speak generally about enforcement from a regulator's perspective, and touch on a few other recent initiatives from the NAIC. Before we jump in, I'll introduce our guest panelists. Excuse me. Our first panelist is Jim Nelson. Jim's Senior Vice President and Deputy General Counsel of First American Title Insurance Company, a firm client. Jim is responsible for all of the legal affairs for First American's domestic title insurance operations. He manages First American's relationships with regulators, state and federal regulators, and state legislators. He coordinates and oversees responses to federal and state regulator inquiries, including market conduct examinations, and just generally oversees to make sure that First American's direct operations and agency operations are in compliance with the various state laws. Jim, thank you for being here and sharing your insights. Sure. Our next panelist is Nick Cant. Nick is Deputy Attorney General at the New Jersey Attorney General's Office. He's Assistant Chief of its Banking and Insurance section. As Assistant Chief, he represents and provides counsel to the New York Department of Banking and Insurance, including in connection with civil enforcement actions and civil insurance fraud matters on behalf of the Bureau of Fraud Deterrence. Nick, thank you for coming, sharing your insights as well. And then you have my colleagues from Dentons, Elizabeth Farrick and Kathleen McCain. Elizabeth and I work closely together to provide regulatory and compliance counseling for insurance companies and financial services industry participants. We assist in responding to market conduct examinations, information demands, and other regulatory actions. And then we represent insurance companies in enforcement actions, and then brought by state regulators, and then also in class actions. And then Kathleen advises insurance companies also in connection with regulatory and compliance issues and market conduct examinations, also on holding company matters, corporate governance, and liquidation, rehabilitation, and other troubled company issues. So as I mentioned earlier, We're going to discuss the new policy initiatives of the NAIC. Elizabeth and Jim will start us off. They're going to focus on the H Committee cybersecurity initiatives, as well as trends in cybersecurity enforcement. Nick's going to give us his perspective on enforcement from a regulator's perspective. And then Kathleen will close us out with some other NAIC initiatives, including the collaboration forums session on algorithmic bias and initiatives regarding privacy and climate change. So with that, I'll turn it over to Elizabeth to discuss the H Committee's cybersecurity initiatives.
Thanks, I appreciate it. So in 2022, the NAIC published formal policy initiatives. They include, as you can see on the screen, cybersecurity, consumer data and AI, and innovation through the new H Committee. They also focus on long-term care insurance, race and insurance, climate risk, natural catastrophes, and resiliencies. Obviously, in our hour here today, we're not going to have time to delve into all of these very broad policy initiatives. We, however, are going to focus on some of the more timely ones, as Grant said, and we're going to start off with cybersecurity generally. Next slide, please. First thing we're going to start talking about is the NAIC H Committee. So the question is, really, what is the H Committee? It's a newly formed committee of the NAIC that has a goal of providing state insurance regulators with resources for regulating cybersecurity, innovation, data security, privacy protections, and emerging technologies. So the creation of the H Committee really brings under one umbrella all of the relevant technology issues that are facing regulators and licensees. We think it's important to monitor the H Committee activities because it should give us and licensees some sort of preview of future regulations that insurance commissioners may be pursuing. And in turn, we hope that it will give licensees an opportunity to implement or start thinking about implementing some roadmap initiatives in-house to help meet those, compliance demands that are going to be coming down the road. Because frequently, it takes years to mature your compliance systems. And so if you start watching these things early on, it helps you know where to go in the future. Jim, I know you've looked at this a little bit, but can you tell us a little bit about the H Committee membership and how it's structured?
Yes, the H Committee is composed of 15 members. The Maryland Insurance Commissioner, Kathleen Bahrain, and I apologize to her if I've mispronounced her name, is the chairman. And there are 15 members of that group. The interesting thing about Commissioner Bahrain is she has an insurance background. She came from a law firm where she did insurance work and then went to the Maryland Attorney General's office where she represented the Maryland Insurance Administration. So she has the insurance background, understands licensees, consumers. She has, in my opinion, the whole gamut of understanding our industry. It's divided, the H Committee is divided into 5 working groups. The Big Data and Artificial Intelligence Working Group, Cybersecurity Working Group, E-Commerce Working Group, Innovation in Technology and Regulation Working Group, and the Privacy Protection Working Group. We're going to concentrate today on the Cybersecurity Working Group, which is composed of 25 members with 4 co-chairs, one of which is Cynthia Amen with the Missouri Department of Insurance. I know there's several Missouri regulators on the call today, so I want to call her out as one of the co-chairs of the cybersecurity group. And then they all have a mission statement, both the H Committee and the cybersecurity group. They both have action plans and projects that they're working on. And for example, the cybersecurity working group at their July 14th meeting developed a work plan which includes the following projects: develop a state insurance regulator cybersecurity survey to better understand cybersecurity policies, procedures, and resources in place at each of the state's Department of Insurance. Consider the development of a cybersecurity response plan to provide insurance regulations in situations to aid in state insurance regulations in situations where cybersecurity events have taken place, to have a kind of coordinated response among the states. And then advise NAIC staff on training that can be provided to the various state insurance regulators, and then monitor state, federal, and international cybersecurity efforts. And that's their work plan for 2022.
Thanks. If we could go to the next slide, please. So the cybersecurity working group met in July, and they came out with a working plan, as Jim just alluded to. And as you can see on the slide, one of their primary concerns was monitoring cybersecurity trends such as vulnerabilities, risk management, governance, and breaches. It's interesting that they're focused on vulnerabilities because we've seen both from federal and state regulators a real increase in focusing on the number of vulnerabilities that entities have, automatically ingesting those into a management system, tracking remediation, and then timely remediating. That's becoming a real focus and something that I think covered entities and licensees are going to need to, throw some resources at to make sure that they can meet some of these initiatives. You also see on this front, state and federal regulators focusing more on increased penetration testing and scans, which leads, obviously, to a higher number of vulnerabilities. The more you scan, the more vulnerabilities you're going to find. And then it makes it harder to comply with what could be some tight turnarounds for remediating vulnerabilities. Now, a lot of these, initiatives are really in their infancy because, as we said, the H Committee is newly formed. They're in the information gathering stage, the H Committee is, with the exception of the underlying bullet point up here, because the NAIC adopted a model law, 668. It's a cybersecurity initiative model law. And that actually predates the formation of the H Committee. But the H Committee has been tasked with helping states implement that model law. So as you can see up here, there's 21 states that have adopted some version of the model law. There are at least 4 states that have some version of the model law currently pending. Several states, 3 I think, have attempted to pass but failed to pass the model law. And then you have 16 states, including New York, that have some sort of statute or regulation that imposes substantive security requirements on licensees other than notification, but that are different than the model law. So this patchwork type of governance is sometimes difficult for licensees and covered entities to comply with because you have different requirements in different states, even though you are likely operating nationwide. Next slide, please.
All right, it's time for our last code word of the day. As mentioned at the beginning of the program, we need to take a brief moment to satisfy CLE requirements by delivering the code. The code word is regulation. If you are in the classroom, please write the appropriate code in the appropriate column on your attendance sheet. If you're attending virtually, type the code regulation into the Q&A section of the right-hand side of your web screen. Please make sure to hit send button so that it registers. And in case you've missed it, the word is regulation. All right.
Elizabeth, if I could, it's interesting, there's like 21 states that have adopted it. There's 4 states where it's pending. So you've got about half the states that are working on that model regulation. But in 2017, when the regulation first was proposed, the U.S. Department of Treasury came out in support of the regulation, but also recommended to Congress that if the states had not passed the regulation in all states within 5 years or 2022, that Congress act to come up with a model cybersecurity regulation for the entire country. In other words, preempt the states. It's 2022. All the states have not adopted the model cybersecurity regulation. So it will be interesting to see if Congress actually acts on this area of the law. It's not going to happen. Let me just tell you that right now. You see that with the privacy issue in this country today. The federal government, Congress has been talking about a uniform standard on privacy regulation for several months now, and it's going nowhere. And so that's why you have a patchwork of state regulation regarding privacy. We're going to have a patchwork of state regulation regarding cybersecurity.
That's a really good point about the preemption, because that would be, of course, quite helpful, but it's really not in the pipework.
To industry, it would be quite helpful.
It would be quite helpful. So let's really jump in kind of to the meat of the model cyber security law from the NAIC. We provided in the materials to you a full copy of the model law as it was passed in Minnesota. I would recommend, to anyone that's involved in this, that, reading through it, it's not too lengthy. But what we've done here is highlight some of the more noteworthy provisions for licensees. At a high level, it establishes standards for data security, investigation, and notification of cybersecurity events to insurance commissioners. It also clearly defines a reportable cybersecurity event as something that results in unauthorized access to, disruption, or misuse of an information system, a system or information stored on it. That's a pretty standard definition of a cybersecurity event. But importantly, it exempts two areas from reportable cybersecurity events. The first is the unauthorized acquisition of encrypted NPI, and the second is it exempts from reporting an event for which the licensee has done a post-event investigation and made a reasonable determination that the NPI was not used and was returned or destroyed. So it exempts from reporting obligations these no harm events. And that's a real benefit to licensees. So that's a real upside, to this model law. Like other risk-based models, it requires programs to be based on your unique risk assessment that your IT group should be performing annually on your core systems and applications. And that's standard, but it goes on to expressly allow covered entities, licensees, to create their cybersecurity systems and programs to be commensurate with the size and complexity of the business activities, and the sensitivity level of the NPI that you're using. So why is that important? That means that smaller companies or companies that are not dealing in highly sensitive NPI don't necessarily have to roll out as part of their cybersecurity program, sometimes expensive tools or, take more onerous steps that wouldn't be necessary based on their business model. And that's not the case, as we'll see with all of the various different 16 other states that have implemented non-model law requirements. Specifically, getting back to the risk assessment, the licensees have the flexibility to determine, based again on that IT risk assessment, what controls are appropriate for their business. So you look at the risk assessment, does it make sense for your business? Is it necessary for your business to employ encryption? Where do you need encryption? So everything doesn't have to be encrypted, but where do you need encryption? Where does it make sense to have multi-factor authentication? And what systems is that necessary? How frequently and what type of pen test do you need to do? What type of scanning needs to be done? Do you need an audit trail? How long do you have to maintain the audit trail? And all of that is based on the risk assessment that you're conducting. And then the entity has the flexibility. The model law also provides some detail as to what would be a compliant risk assessment. So it has direction as to what an entity needs to do to have a compliant risk assessment around which to base their cybersecurity system. One of the most important things here, from a licensee's perspective for the model law, is it clearly establishes the confidentiality of the materials that a licensee may be asked to produce in an investigation or enforcement action that comes after a security incident. And this is really important because frequently the materials a regulator is going to request from an entity after a security incident have to do with their multi-layer security systems. And so it provides, the information is highly sensitive. And if it came out publicly, it can literally provide a roadmap to a nefarious actor as a way to breach your system. So, you know, disclosure of those materials could likely lead to greater harm to both the licensee and your consumers, you know, your customers, than the underlying security incident. So that confidentiality provision is really important here. Jim, could you, from what you've seen from your industry peers, tell us some of the benefits that you see of this model law to consumers in particular?
Sure. Benefits to consumers include several factors: the development of an information security program, investigation of a security event, and reporting or notification requirements. And I want to talk a little bit about each of those. The cybersecurity, the model law, requires a company to develop an information security program. It requires the company to look inward. How are you managing your cybersecurity? How are you protecting the data? How are you protecting consumers? Absolutely fine. The program must be developed in coordination with the risk assessment that Elizabeth was talking about, and that the law requires licensees to conduct. Among other things, the program must establish a data retention schedule. In other words, you can't just collect the data and then put it in your system and leave it in your system forever and not deal with it, not get it out of your system. Companies today, and particularly like mine in the insurance industry, will collect the information, and as soon as we're through with it, fortunately in the title insurance business, we're transactional based. We have a transaction with you. So we're through with it. Get it out of our system. And that is one of the aspects of the information security program that companies have to develop. Create procedures to routinely assess your business risk. This kind of thing is evolving. As you develop through innovation and other products, you're continually experiencing possible additional risk. So you've got to look at your program and continually, routinely assess the business risk involved in that program, and consider your cybersecurity risk as part of your management process. Identify and implement measures to control access to private data, and provide oversight by the board of directors at least annually. These are the main elements, the 5 main elements that the information security program should contain. And that benefits the consumer. It's protecting their data. It's identifying what data is being collected, and it's building protections around that data. And then investigation of a security event. It requires a company, if you've had a security event, if you had an intrusion, or if you've had a breach, it requires the company to assess the nature and scope of the breach, then identify any private information that may have been involved or compromised, and then restore the security system to prevent further data breaches. Companies sometimes are infamous for, okay, we know we have a problem, we know what the problem is, we've identified it, we've assessed it, and they just kind of leave it at that. They don't remediate. They don't fix the problem. Well, with data security issues and data, you've got to fix the problem, and promptly. And then notification requirements. The model law requires notification if private information is breached in a cybersecurity event to the regulator, to the insurance commissioner, or the insurance regulator, within 72 hours, generally, from a determination that a cybersecurity event has occurred. From a determination that a cybersecurity event has occurred. That's very key in your cybersecurity awareness. And it's interesting that the consumer advocates, the one flaw or the one thing that consumer advocates believe that the model law does not do for consumers is require notification to the consumer. The notification is to the insurance regulator. It's not to the consumer if there is already an applicable state law on data breach notification to otherwise. The model law doesn't address notification to the consumers, but if that state has a requirement, for example, a separate statute then of course you have to follow that. But the model law does not have that requirement in it of notifications of consumers. The consumer advocates are critical of the model law for that particular aspect.
It's not a huge hole. There are 29 states that have their separate notification requirements, so it affects a handful of states.
Right.
But, you know, since 29 states have passed their own notification requirement.
Well, and everybody, whether it's, you know, industry, whether it's consumer groups, you know, privacy, data security, any kind of model law that goes in, every group wants their laundry list put in there. And when it doesn't get in there, they're disappointed.
Right, right.
Yeah.
What specific benefits to the regulator do you see from the model law?
Well, here with the regulator, it gives the regulator the power to examine and investigate into the affairs. Now, that's pretty broad language. Into the affairs of any licensee to determine compliance with the law. So that is a very good tool in the toolbox of the regulator. It allows the regulator to enforce the act, to enforce the Model Act. Whenever the insurance commissioner has reason to believe that a licensee has violated the law, the insurance commissioner may take action that is necessary or appropriate. Again, broad language that is necessary or appropriate to enforce the provisions of the law. Necessary or appropriate could be anything from a fine or penalty all the way up to suspension or revocation of a license, or the imposition of a huge penalty on a company. And last, let's talk about penalties. It allows, the model law allows the insurance regulator to assess penalties. The states have different versions of the model law, and so some of the states have different provisions for penalties. In Connecticut, for example, after notice and hearing, the commissioner may suspend or revoke a license and fine a licensee up to $50,000 for each violation and bring a civil action to recover if necessary. There we go with for each violation, which again, very broad language. Does that mean, for example, all of the images you have in a database, which has 850 million images in it? Or does that mean one event? Yeah, there was one breach, there was one intrusion. You know, are you going to charge $50,000 for that? Or are you going to charge 50,000 times 850 million?
Now, while it's, you know, creates relatively significant burdens on the licensees because they have to craft these compliant cybersecurity systems, there are some benefits to licensees from the model law, though, aren't there?
Yes, there are some. The model law provides a clear framework for compliance. It's not prescriptive, it's risk-based, it provides a clear framework. It tells you specific requirements related to maintaining an information security program, a risk assessment management, how to deal with your third-party providers, incident reporting, investigation, notification like we discussed, and then annual certification. It requires the company to go and look at it at least once a year, and that's a good thing, I maintain. It has a reasonable definition of a cybersecurity event. The model law does not cover attempts to access non-public information and covers unauthorized acquisitions of encrypted non-public information only if the decoding key is also acquired. The model law excludes from the definition of a cybersecurity event where the licensee determines the acquired non-public information was unused and has been returned or destroyed. Now, let me take a little side deviation here and read you some language from the CFPB, my favorite regulator, the CFPB's Consumer Financial Protection Circular 2022-04. Inadequate data security can be an unfair practice, in other words, a UDAP violation, in the absence of a breach or intrusion. So you don't have to have a breach under the CFPB circular. You don't even have to have an intrusion, but it could be a UDAP violation. Further, actual injury is not required. So talking about class action earlier and actual injury to people, the CFPB says actual injury is not required to satisfy a UDAP violation of cybersecurity. And then practices that are likely to cause substantial injury, including inadequate data security measures that have not yet resulted in a breach, nonetheless satisfy unfairness. So, you know, how in the world are you going to know what is unlikely or are likely to cause a substantial injury? You know, it's just, it's amazing. They cited an example in there, the Equifax cybersecurity event. And they said Equifax violated the prohibition on unfairness by using software that contained a known vulnerability and failed to patch the vulnerability for more than 4 months. So is this the expected standard? We were just talking about identifying vulnerabilities and how that can balloon up to, you know, hundreds, if not thousands of vulnerabilities with a company's limited resources. Now you're supposed to remediate all of those known vulnerabilities within 4 months. That's an unreasonable standard, in my opinion. Also, the benefit to companies, risk-based framework, it's not prescriptive. Elizabeth has talked about that. Based on the sensitivity of the non-public information used by the licensee or in its possession. Title companies like mine, we have lots of public information in our databases, but it's publicly available information. It was information that we have retrieved, images that we have retrieved from county recorders in the chain of title. So publicly recorded documents by a government entity. There's no strict liability for an intrusion that does not cause result in harm. That is a great benefit to the licensees. In the model law, it's not apparently what the standard that the CFPB is going to hold everybody to, but it's in the model law. Does not create a private right of action. This is important. Elizabeth mentioned this earlier. The model law itself cannot be construed to create or imply a private cause of action. However, nor may it be construed to curtail a private right of action, which would otherwise exist in a given state. But there's no specific language in it. Now, dealing with industries, licensees, the U.S. Chamber of Commerce, you will see industry and the U.S. Chamber in these model laws. We're doing it in privacy. We're doing it in cybersecurity. You will see on that list of requirements or requests that the law does not contain a private right of action. It's clear language on that. And the reason of that, and my friends here from Dentons, who are the class action attorneys, first comes the regulatory action, then comes the class action. And often the class action is worse on a company than the regulatory fine or penalty itself. The regulatory class action, the regulatory enforcement action comes and goes, you're done, you're finished. Class action can last 10 years or more and cost millions of dollars. But that's the standard pattern. First comes the enforcement action, then comes the class action. And then the confidentiality. Oh, let me back up. There's another thing that you will see industry and the chambers of commerce wanting on their laundry list in these model regulations to deal with privacy, cybersecurity, everything coming down the road. And that's the right to cure. You know, instead of, we talked about this earlier today, the gotcha, the enforcement by gotcha, or the enforcement by regulation by enforcement, or the previous group talked about not getting any clear guidance from the Department of Insurance in California. Industry and like the Chambers of Commerce, we believe it's fair if you, particularly when you've got broad language as a regulator looking at the cybersecurity, and you see something in the cybersecurity program that you don't like or you think is inadequate, you haven't given us any guidance. You haven't given us a bulletin. You haven't given us any specifics except this broad language. It's like pornography. You know it when you see it, you know, but the regulator comes in and says, you've got this violation here. Well, we didn't know we were in violation. You didn't tell us. We'd like to see a notice and a right to cure. You know, fix your system, no harm, no foul, particularly when no consumers were involved. Fix your system and then move forward. That's what I think would make the law better. But it does not create a private right of action, which is great. Elizabeth talked about confidentiality. That is equally as important because, again, if the regulator gave all this information out, made it publicly available, then the class actions would certainly follow. And then also the bad actors would have a roadmap into the vulnerabilities of a system.
I think we're running a little bit behind schedule here. No, it's fine. I just want to make sure we save enough time for Nick and Kathleen. I think this dovetails nicely. The discussion about like the CFPB insurance circular letter is a great comparison against Model Law 668 because there are benefits to licensees under Model Law 668. The similar comparisons can be made to New York's Part 500. So the DFS promulgated Part 500 back in 2017. It, in theory, is a risk-based system, but it hasn't in practice been used that way by the DFS. They interpret it as much more prescriptive of a regulatory framework. So you still have your risk assessments. So those risk assessments, the actual components that you need to conduct are not as defined. But the DFS has taken the position in investigations and enforcement actions that it's nearly strict liability. If an entity suffers from a security incident, it appears that under the DFS interpretation of Part 500 that that's de facto evidence that the covered entity has not complied with the minimum cybersecurity requirements set up by Part 500. I think it's also important to note that the DFS earlier this year, in a relatively unusual procedural move, published some proposed draft amendments to Part 500. It's not in the formal notice and rulemaking process, but prior to entering into notice and comment period, they have these draft proposed revisions, and they ask for comments from industry participants. If adopted, the proposed draft amendments, which I included a red line of the proposed draft amendments against Part 500 in the materials, they're very extensive. They touch on 20 of 23 of the different provisions, but they really turn Part 500 into a truly highly prescriptive cybersecurity framework, and they require, and I'll run through this quickly, just, regardless of your size. So any covered entity, they require penetration testing and vulnerability assessments. You have to manage your user access privileges. You have to perform asset inventories, do email filtering and monitoring, and then you have to have these incident response and business continuity and disaster recovery plans. Those are significant monetary obligations on certain covered entities. It also imposes significant obligations on CISOs and boards of directors from a governance perspective, which will require many entities, to reform how their how their cybersecurity groups are set up. And then, perhaps most critically, it significantly expands the scope of penalties that the DFS can impose. So it applies per day penalties or penalties based on the amount of NPI that you hold. So the penalties could be massive, bankrupting billions of dollars of penalties. A lot of this, the DFS already takes the position that Part 500 allows for this, but this change, I don't think Part 500 as it is now allows for any of this. This change would make it so. And so it should be of heightened interest to anyone in this industry that that's happening. And with that, I think we can turn it over to Nick.
Yes. All right. Okay. Yeah, we'll shift gears a little bit here, Nick. Want to get your perspectives on, enforcement, both of, NAIC model laws, and I believe you dealt with laws that are not model laws, but for which model laws exist, and having some experiences there that may be insightful.
Right. All right. Is this on? Okay. Yes, I work at the New Jersey Attorney General's office, and did we say I'm speaking in my personal capacity?
Oh, I'm sorry. Yeah, very good.
I have to say that. Yeah. Okay. So my client is the Department of Banking and Insurance, which is this other state agency, including the Commissioner of Banking and Insurance. And I guess speaking about enforcement generally, setting aside the insurance fraud, which we usually go to court on, that's the non-licensee stuff, and we do a lot of those cases. On the licensee side, I think it's correct that most of the statutes provide the Department of Banking and Insurance the ability to go do these examinations freely. They can also do these subpoenas, administrative subpoenas, without being in litigation. They're mostly doing all of this on their own. However, they come to know about the stuff, violations from an examination, whatever it is, they find out on their own, and they also settle stuff on their own. They'll go out, talk to the company, and they can settle on their own. My office won't be involved at all. And frequently, I think the bigger parties, like the insurance companies, they are going to settle. They aren't going to fight back. They want to keep a good relationship with them, whatever the reason is. Those cases that they're not able to settle, then it comes to my unit. Makes its way to my unit. We have 14 attorneys, including myself and the assistant chief and chief. We do all the legal representation for the department. So most of the license fee stuff, it's going to go into administrative, not really a court, it's the Office of Administrative Law. It's going to be a two-step process, usually. So the commissioner, as we heard, the statutes are going to say the commissioner can assess the fine. So that's kind of telling you it's administrative. So the commissioner could hear the case herself like a judge and assess the fine, but she's too busy. And also the reason that I think usually we attorneys don't know about the cases is because it's just a volume thing. They have so many cases, we have so many cases, we can't be involved in everything. So the commissioner's not going to hear the case herself. She's going to send to the Office of Administrative Law, where they have these administrative law judges. They're going to hear the case. They do an initial decision. It's not really binding. Then what we call exceptions are briefed to the commissioner. The commissioner will read that from both sides, read the judge's initial decision, and she'll issue a final decision. That is essentially a judgment. That's the same as if a trial judge in the courts issued a judgment. And that is appealed directly from there to the appellate division. Moving on to some of the NAIC model law stuff, again, I said some of the bigger people might settle what we call insurance producers, people who sell insurance, or public adjusters, people who are private companies who are supposed to help an insured person get a larger amount from the insurance company. Those people will sometimes want to fight back, and we certainly have a lot of cases against public adjusters where they are claiming that, we're claiming that their contract needs to let their clients out at any time. So if you're their client, what they're doing is a contingency fee, and it's anywhere from 10, 20, 30% of the total award from the insurance company. So we say you need to let your client out of the contract anytime they want to get out, but maybe the client has to pay for the quantum merit of the expenditures of time. And they're saying, no, once 3 days go by, this is in the contract. Once 3 days go by, you're locked in. We're getting 30% of whatever the insurance company gives you, no matter what. You can't get out. And sometimes it can be a lot of money at issue. So that's something that we're fighting with them. And anyway, some of these people are claiming that the NAIC law says, oh, you can lock people in after 3 days. And to me, to us, it's an easy response that, oh, no, that's not the law. The law in New Jersey is the law in New Jersey, not this model law. So that's one thing where I think the NAIC stuff is coming up.
Sure.
So.
Very good. So regardless of the model law, making sure you're in compliance across the board and be aware of those nuances.
Right.
Next, does your office handle the appeals to the courts after the final order from the commissioners come down?
We do, yeah. Usually the same attorney who handles it at the trial level handles the appeal.
Got it.
Yeah.
Right.
And just one other question. What is the process? How is the administrative law judge appointed? Is that a random appointment or?
I believe they're chosen by the governor.
Oh, I know. Yeah, got it. But like for a particular case?
Oh, it goes down. So we issue our charging document, which is usually drafted by us attorneys, and then the commissioner signs off. It's just, we call it an order to show cause. It's really just a charging document. Mm-hmm. And if they answer it, then the case is transmitted to the Office of Administrative Law. I'm not sure how they pick who gets it, but I do see some trends. Like I think maybe they think this judge has had a lot of cases of this type, and they give it to that judge.
That makes sense, like experience in that arena.
But New Jersey has a separate Office of Administrative Law. It's not employees of the banking department, for example, that serve as the administrative law judge.
That's a common mistake, actually, because like I had told everyone I had a call today at 3 o'clock on an administrative matter, and it got adjourned because they did an interlocutory appeal to the appellate division, and their appeal incorrectly says that the initial determination was by the Department of Banking and Insurance.
Right.
But the Office of Administrative Law is a totally separate thing. And I frequently have to say this to people, what we think, and maybe the employees of the department think, that's just an opinion. It's ultimately the judge who makes his recommendation to the commissioner. And only what she says at the end of the day, which can take a long time to get to that point, that's all that matters. And then the appellate division, of course.
Mm-hmm.
Got it, thank you.
All right.
I mean, I think what we've seen, I've been talking about the NAIC model laws, what many in the room, insurers likely know, is that the NAIC will adopt a model law, but not every state will adopt this exactly as written. They, like New York, may only adopt a paragraph that they like. Other states will do something different. And even if a state adopts the same thing as a model law, two states may interpret that law differently. Mm-hmm. So it makes compliance by the insurance companies difficult.
Mm-hmm. To say the least.
So Kathleen, do you want to tell us about the remaining initiatives?
Okay, so I guess, so if I can say algorithmic bias the right way every time I say it, do I get a gold star? Okay. Okay. So one of the things that the H Committee is doing is they're going to start, they have a collaboration forum that they're talking about, and it was kicked off in April, at the April meeting, I believe. So what that's intended to do is that there are topics that are important across all of the letter committees. And that means the letter committees are the committees of the NAIC on different matters like property and casualty and life and annuities, and the new H one, which is on cybersecurity and innovation. So if there's a topic that is important across the NAIC and they want to investigate it, they're going to send out an invitation, and then they'll do the collaboration forum to talk about it. So they have a consistent language, so the definitions are the same, so that the committees are all working on that issue on the same path, so that one's not ahead of the other. So, and the collaboration forum is for them too. So the first collaboration forum is on algorithmic bias. On algorithmic bias. And that was described by Kathleen Bahrain as systematic errors in AI, machine learning driven computing systems that results in discriminatory outcomes. That's a lot of big words. But what it is that insurers use data and algorithms in lots of different ways, in lots of operational areas. Rating and underwriting and marketing and claims handling and fraud detection, and probably so many others that I can't think of right now about how data is used. And the way they use it, bias can creep in because AI is developed by humans. Humans have biases get involved in the data and in the algorithms. So they're going to take a look at it and see how they can mitigate those risks and what is the best regulatory framework for addressing it. So the first thing, and they're going to look at data from every aspect, from data creation, data analysis, and then extrapolation. So the first thing that they started looking at, the issues that are going to be covered by the collaboration forum was what kind of algorithms raise concerns for regulators, how bias might arise in algorithms, what tools are effective to mitigate that risk, and what are the potential ways regulators can address it in algorithms. So in July, they had what I believe was it's called a fly-in, which I think was an educational forum for regulators to come in and learn about data and collection and algorithms. It was an educational forum. And then in the August meeting, they had an open session on algorithmic bias and ways to discuss things, how to address it. And one of the things they were talking about is how do you address the bias is, can you do it through the insurer's risk management? Can you make it a formal risk management, part of your risk management by establishing processes and procedures and having training and then having consequences if those processes are not used correctly? That would be internal compliance ways. Another thing that they've addressed is transparency, because models are hard to understand and hard to describe, and thinking of ways to describe algorithms and data in a simple manner so that consumers and others can understand that. then the committee is going to use the information that's gathered, and I forgot to mention that the ways that they're gathering this is that the AI and big data work stream is doing surveys. I think they recently did one on auto insurance that went out, I think, maybe 10 states. I don't think they went to all states, but they did one on auto insurance and sent out surveys so they can find out how insurers are using the data and creating data and what the sources of that data are in auto insurance. They're looking at the results of that now. They're then going to send out a survey on homeowners, and they'll eventually send one out on life insurance, I believe. So ultimately, this will lead to ways that the regulators will address in how they regulate the use of data. And so I think what we're going to see is, as the innovation in insurance products continues to grow, regulation will likely follow. Because we've already seen it in, I think, maybe at least 5 states. There is, New York sent out a circular letter, I think, in 2019, cautioning insurers that they need to make sure that the data that they're using in life insurance is not unfairly discriminatory when it's used for rating or underwriting. Connecticut sent out a notice that is similar, cautioning insurers how they use their data. Colorado has a new regulation, and I think they announced that they're going to send out a survey to 10 of the top life insurers to find out how they use their data. Tom Hampton, when I talked to him last week, hi Tom, if you're out there, you're still out there, is that the District of Columbia is now doing something as well on taking a look at how data is used in auto insurance in DC and whether or not it's discriminatory. So that's about 1 minute before the end, right? Mm-hmm. 1 minute before the end? Okay. Or I can say something about some other things. I mean, I can do quickly some other things. Climate change continues to be a big issue that they're taking a look at, and they've been talking about adding climate change risks and questions into the financial analysis handbook, into the financial condition examiner's handbook, and into the ORSA thing. So they'll talk about climate risk with regard to investments and the like. And I know, Jim, you had a quick comment about climate change.
Well, yeah, I mean, the climate change is started in California, the climate survey, the diversity survey, the carbon risk initiative, all of these surveys generally started in California. They're moving across the country. So companies have to pay attention to that. And several of the regulators have joined with California now, so that at least there's, a group of them that come with one survey instead of 50 different surveys.
Yeah, so I think there's maybe 14.
14, I think that's right. That's right. And that's always a benefit to the industry when the states will come together and do one survey instead of 50 different surveys. And, the disaster recovery program is another one. It started here in New York. That's going to sweep across the country. I thought my company had a good disaster recovery program built into their business continuity program. It's one of those things where, I wake up in the middle of the night at 2:30 in the morning and go, oh my God, what have I missed? And I'm like, I'm not going to worry about it. I'm going to call Dentons in the morning. And that's exactly what I did. I called our Dentons team. They looked at it for us. Said, you got to have some tweaks. You got to have some things to fix that. We did our New York filing last week, and now we're prepared for all the other states to come in and adopt the same kind of program. We'll just tweak it, but we've been proactive, and we're ready for that sweeping across the country with disaster recovery programs.
So what it was specifically was a separate filing for a New York-specific disaster recovery program that had to have New York-specific elements, like a New York business continuity leader and a New York disaster coordinator, and then a primary and alternate to coordinate with the New York Department of Financial Services in the event of a disaster. And so while all of your companies, I'm sure, have entire offices dedicated to business continuity, you may not necessarily have the New York specific minutia that was required of the New York Disaster Recovery Plan. So
be proactive.
Yes.
And get out in front of it.
And there is talk from the NAIC that other states may adopt these similar type of like state specific disaster recovery plans.
No questions? Well, I think everyone would love a cocktail. Thank you, everyone, for joining and for the nearly 70 people who've joined us virtually today. This was really fun. Before we head out to the cocktail reception, I'd just like to thank the talented group of business services professionals that helped us put this together. Dan Gruber, sitting right here, Regina Smith, who's joining us virtually, and Dan Gold, who helped with all the onerous CLE requirements for the various states. A couple of housekeeping things. Don't forget to turn in your CLE forms. You worked very hard with those code words, so let's get our CLE credits. If you are joining virtually, your attendance was recorded on the WebEx platform. And if you could fill out a survey, that would be great, but don't let me hold you up from your cocktail. And you'll get your CLE certificates within 15 to 20 days. So with that, it's a wrap, and thank you, everyone.